Well, good morning, everyone, and welcome back to the second day of AFME's fourth European Compliance and Legal Conference. And I hope you are enjoying the virtual format. We've had some great feedback on that already. If there are any problems you're having with that, just go to the AFME events team booth, and you will be able to get some help there. Delighted to see so many people back again this morning. In case there are new faces, just check that you've configured your time zone correctly to make sure you don't miss any of the sessions. If you happen to be in the UK, you need to select Europe, London. Not sure if that's a sort of Brexit related point or not. And then in terms of Slido, you can interact there, engage with the panels, put your questions forward. That's very, very helpful. Certainly very helpful if for the moderators of all our panels, if they do get some really good questions in from the audience during the session, which they can then put to their expert panelists at the end. Also would encourage you to go to the booths for our sponsors and our speakers and other participants and get to meet some new people there. So just looking at the program, just looking through the program again this morning, I mean, Barrett yesterday said it's action-packed, and it's absolutely right. We have an amazing program and some great speakers, just sort of four areas to flag, apart from Brexit. Our panel on new trends in conduct, that's led by Steve Stromberlin, who's a great supporter of this conference. Really amazing industry speakers from UBS, Natixis, and the FCA. Panel on the conduct agenda is going to be led by Louise, with industry speakers from Standard Chartered, Central Bank of Ireland, and the FMSB. And thank you again, Standard Chartered and Central Bank of Ireland, coming back for this session this year. Really great session last year in Paris, you may remember. Panel on Mars, led by Nick Bailey, many of you know very well. Great speakers from BNP Paribas, CNMB, and Latham Watkins. And then don't forget the excellent pre-recorded sessions. We've got IBOR Transition, led by Clifford Chance, with UBS, Natixis, and the FCA. They seem to be a bit of a team today. And on data, led by Vivian Arts, with Citigroup and the European Data Protection Supervisor. So those pre-recorded sessions are available for a couple of weeks. I would encourage you get them in your diary. Obviously, you can't listen to two at the same time, but get those in your diary. They are really well worth watching, including the ones from yesterday. In addition, you'll have spotted the virtual mind reader session. I'm curious to see how that goes. You might need to download Zoom, I think, for that, if you're allowed to by your firm. So before we come to the first panel, I'd just like to introduce Alistair Stables. Alistair is Head of International Regulatory Relations at Bank of America, and he also, I'm very glad to say, provides great support to AFME as co-chair of AFME's Compliance Committee, which you heard a bit about yesterday from Alistair's co-chair, Barrett Samadi. So before we get to the Brexit panel, I'd just like to hand over to Alistair to say a few words.
Thank you, Richard. Good morning, everyone, and welcome to the second day of the AFME Compliance and Legal Conference. When we originally discussed holding this as a virtual conference, I have to say I was somewhat skeptical. But having attended yesterday, I'm a convert. I learned, for example, yesterday that there is such a thing as a standing desk treadmill. So, something new for me to learn. But as a result of that, and being a convert, I'd like to say thanks to the events team and the compliance team at AFME for making this work. As Richard mentioned, today's panels cover very important topics. We've got Brexit, conduct and culture, and the market abuse regulation. And these are all important and pressing issues for compliance and legal functions, although it often feels to me as though we've discussed them all at some length before. And that same feeling will be known to many of us as a result of the working posture created by COVID-19. I think Groundhog Day is an expression that many of us have heard all too many times. And it can add to the feeling that the challenges we're facing, cannot be overcome. But actually, I'm quite optimistic that we will overcome them. And some of that optimism is generated by the way the financial system has proven strong and resilient during difficult times. Thinking back to the 2008 crisis, the general impression I have is that now we're stronger and better prepared to face shocks and emergencies. And firms and regulators have reacted quickly to the pandemic, to the initial uncertainty and the difficulties that we faced. And the positive results that have come from that have been thanks in a large part to a stronger regulatory framework. And that includes the focus on non-financial resilience and outsourcing and third parties. But it's also thanks to forums such as AFME and its Compliance Committee. So in a shameless plug, I'd like to say that Compliance Committee in AFME allows its members to share best practices and to establish solid relationships with national and EU regulators. One of the steps that the committee has consciously taken under Barrett's leadership is to become more EU focused. And I'm very pleased to say that an example of that and the benefit that we're seeing from that is in relationships with EU regulators. We can't predict the future. The pandemic has shown us that. But I am confident that we can help shape events around us. And I'm sure that one of the benefits of attending today will assist in shaping those events. So with that, I thank you again for attending, and I hope you enjoy the day. And I'll now pass you back to Richard to introduce our first panel.
Thank you very much, Alistair. So it's my pleasure to introduce our first panel, which is about Brexit. It's good to know that industry experts have somehow managed to keep a focus on Brexit, even through the sort of COVID crisis and remote working. And this session is entitled Brexit, the Beginning of the End. And I'd like to think that's a kind of positive title, but maybe we'll learn from our panel. So I'm going to hand over with thanks to Caroline Dawson, who is a partner at Clifford Chance, and we'll perhaps learn whether or not this is indeed a positive beginning of the end.
Brilliant. Thanks very much, Richard. And yeah, I mean, hopefully there are some positives coming out of this. So this morning we're looking at the final preparations for the UK's departure from the EU at the end of this year, and also what the future relationship between the UK and EU might look like. And to discuss this, I'm joined by three panelists with an in-depth knowledge of all things Brexit. So we've got Arvid Koller from AFME, Caroline Boone from Barclays, and Rob Price from the Bank of England. So just to start, I guess, with a quick reminder of where we are so far. So the UK left the EU at the end of January this year, and since then we've been in a transitional period during which the UK continues to be treated as if it was a member state, while the UK and the EU negotiate an agreement on their future relationship. And that transitional period is set to end at the end of this year. The deadline for the parties to agree an extension expired at the end of June. And if we're going to get an agreement ratified by both sides in time for year end, it really needs to be reached in the next few weeks. So we've got the UK looking to the council meeting on the 15th of October as the key date, while the EU is looking more towards the end of October. So how likely is it that we're going to have an agreement in place by the end of the year? There has been some progress in talks, but there are some significant issues which are still unresolved, including the UK's approach to state aid and the question of fish quotas. Looking at analyst predictions on whether or not we might fail to reach an agreement. So while back in June, the probability of no deal was probably hanging around 10 to 20%, I think now we're seeing predictions of closer to 50% probability of no deal, with some outliers looking at 80%. But even if we do reach an agreement, I suppose maybe the thing to remember is that free trade agreements don't typically provide for much in the way of liberalisation of cross-border financial services. Or in the way of mutual recognition of financial regulation. And even if the EU-UK agreement does go further than previous FTAs, that final agreement isn't going to replace the existing passport regime. And I guess in any event, because of the time that it takes to restructure businesses to account for loss of the passport, firms have essentially been preparing for a no Brexit deal all along on the assumption that we're going to have a cliff edge at the end of this year, where the UK moves overnight from being treated as an EU member state to being a third country. So looking at the steps then that regulators and firms have taken to prepare for this cliff edge, Arvid, coming to you first. So we've seen the EU take some steps to mitigate the impact on cross-border business. Can you give us an update on the latest developments and where we are with that?
Yeah, of course, Caroline, and good morning to everyone. Obviously, a lot has happened on Brexit over the past years, and that happened at firm level, where wholesale banks have taken extensive preparations to continue to be able to service their clients as best as possible across Europe. But also, of course, we've seen things at regulatory level as well. And I think there we can probably make a distinction between the kind of EU level, but also the member state level. And if we do start with the EU level, perhaps the most important one, important announcement that we've seen over the past few months is certainly the Commission's announcement on time-limited equivalence for UK CCPs. And that is time limited in the sense that it will apply for 18 months until summer 2022. And this decision, this announcement from the Commission is clearly very important. It addresses an important financial stability risk, and thereby also ensures that EA firms have continued access to clearing services. And equivalence for UK CCPs has always been dealt a bit outside of the realm of the general equivalence debate, I'd say, and also outside of the FTA discussions that we've obviously seen quite a lot in the media, and how that is panning out and has panned out over the last few weeks and years even. But very early on in the Brexit process, the Bank of England and the ECB were very clear that access to clearing it does present a stability risk. So it's very good to see that be confirmed by the Commission. Subsequently, we also saw the EMIR delegated acts being published. We saw that there's been an MOU being put in place between the ECB and the Bank of England, and those were preconditions for ESMA recognizing UK CCPs, which now has been confirmed as well. But within all of this, I think it's also important to keep in mind that the European Commission's clear message in publishing that decision was also that EU firms should, over this time, try and reduce their exposure to UK CCPs. And also, of course, that EU CCPs should use that time to build up their own clearing capabilities. So we'll see how that works in future. Other than UK CCP equivalents, we haven't seen too much on equivalence, to be honest. But there's one area where we do know there will be no equivalence, and that's on MiFIR Article 47, where at least in the short and medium term, the Commission basically ruled that out. And equivalence under MiFIR Article 47 would have allowed UK firms to provide MiFID investment services to eligible counterparties and professional clients in the EU without a license. But we know that this will not happen, at least for now. So I think a lot of focus has shifted from that EU level to the national level. And there, of course, I'm sure many in the audience will have followed Brexit over the last few years as well. And you might all remember that we've obviously seen a lot of discussions last year on member states putting in place no-deal regimes. I think it was 16 or 18 or so EU member states out there who did that. But it's really important to keep in mind that many of these no-deal regimes do not actually apply at the end of the transition period. So what we do have, however, are some kind of existing national third country licensing regimes. But firms are really facing a patchwork approach of these regimes, and as they all differ slightly in their scope, in which activities would be allowed to be provided from a third country, and even though probably the UK is a bit of an outlier in all of this, and I'm sure we'll come to this with its temporary permissions regime, but in the EU, a number of countries do have some help provisions in place. Some other countries don't go quite as far, and some countries do not have any provisions at all. So I think firms are really needing to work very hard to establish what they can do, where, and how exactly. So to kind of wrap it up, I guess, we have seen a few mitigating actions. We also still lack clarity on quite a number of mitigating actions on the share trading obligation, derivatives trading obligation, and data adequacy perhaps, but I'm sure we'll come to this later, so I won't go into that now.
Brilliant. Thanks very much, Arvid. Yeah, so some mitigating steps, but really looking on the licensing front, I suppose, at least looking very much back at that patchwork of different national member state regimes. And then obviously the UK has been looking at taking mitigating steps as well, Rob, to deal with the loss of the cross-border passport. Can you tell us a little bit about some of the steps that we've taken in the UK?
Of course. Thank you and good morning, everybody. So, as Arvid mentions, the general approach in the UK has been to try and ensure sort of a smooth transition into the new arrangements. And I think that broadly will be helpful to people. It has the unfortunate side effect of an awful lot of three-letter acronyms beginning with T that all seem exactly the same as each other, but one advert or plug I would make at the beginning is there is on the Bank of England and FCA website a huge amount of material that you can work through. So if you are looking to conduct business in the UK from a sort of legacy of a passporting approach today, then I would really encourage you to go through that material if you haven't. It's probably going to be easier to digest than the brief summary I can give you now. So probably the main or most high profile measure is the one Arvid mentions, which is the temporary permissions regime. This effectively allows a firm that has a passport at the end of the transitional period to apply to come in for a 3-year temporary authorization that is automatic. Currently, to get it, most firms I think have already put the notice in or have been brought in because they've applied for a permanent authorization. For firms wanting to come in now, they can only enter, at least on the banking and insurance side, by applying for a permanent authorization. There is then another arrangement, which I'll touch on in a minute, which is a series of runoff arrangements. Those would be used for firms that don't apply to go through that process or who enter the temporary permissions regime but then exit without authorization. And very much the focus of firms that are not moving into a permanent authorization will be to use the time to run off their business in an orderly way. And I think we'll probably talk on rules later, but broadly the position for a branch, a European firm that is passporting in under today, is they will move to the same regulatory requirements as a branch coming from another third country, such as America or Switzerland. There is no assessment of threshold conditions as firms enter that regime, which would be the normal authorization route, but from the point when it switches on, the PRA will be able to look at compliance with threshold conditions and act if there is an issue. So it's a slightly different position in that regard to the passport. The one change I think that's worth flagging that is quite significant for banks is around depositor protection, because obviously today a European firm accepting deposits in the UK is protected by its home state scheme. That will switch off at the end of the transitional period, so they will move into the UK depositor protection regime. There are some disclosure and logistical requirements that flow from that, and those are a particular priority to make sure firms are on top of. And there was a statement we issued in September explaining that the firms who are in the process of applying for a Part 4, so a permanent UK authorization, will all move into the temporary permissions regime at the end of the transitional period. So they will all need to be ready with the disclosure requirements and the few operational requirements that do change at that point. And just carrying across the FCA side, they have a parallel regime, obviously, for the firms that they're responsible for, and they have an equivalent temporary marketing permission for fund authorizers, for fund distributors. It's, as I mentioned, there is a runoff regime for firms who either don't go into this temporary regime or go into it but exit without authorization. That typically allows 5 years for regulated activities and longer for insurance activities. And it has two divisions. One is what's called contractual runoff and one is supervised runoff. Supervised runoff is probably the slightly more intensive version. That will be typically a firm with a branch here today, but could be certain cross-border firms with top-up permissions. They have rights to carry on performing their existing contracts with certain ancillary rights, for example, to provide risk management to their clients. That's treated as though they were authorized during the period, and they are subject to supervision by the relevant regulator and subject to similar rules to a branch. The contractual runoff, which is typically cross-border, doesn't have the same supervision by the UK authorities and relies on the supervision by the home state. So that's sort of a very brief canter through the regime for firms. The normal process is that a firm would have between 6 and 12 months to apply for authorization. That has been extended. So effectively, the process of moving to permanent authorization could potentially run for the full 3 years, though obviously we'll start to see firms moving through that process as we go. And then just to round out the rest of the regime, for CCPs, there's a temporary recognition regime that will last for 3 years. I think there's currently about 48 CCPs who are on that list. You can get it on the Bank of England website. There is also a parallel runoff regime for firms that are for CCPs that are not entering it. There is also a similar regime for central securities depositories. The timing is slightly different on that. That will be the end of that will be triggered by reference to the making of an equivalence determination when those go through. And there is also sort of very techie but critical temporary designation regime in relation to settlement finality benefits. And again, you can get the list of firms that have moved into that on the Bank of England website. And then just finally, the FCA has been going through the process of recognising overseas investment exchanges. So there's a broad, and also looking at trade repositories. So there's a broad sort of coverage to try and ensure that continuity.
Thanks, Rob. Well, I think we are moving to me now to talk about what steps firms have taken to prepare, and we're certainly very grateful to have, as you say, all of the information that you've mentioned that you've put up on your website, on the Bank of England and the FCA websites, which obviously we have been trawling through in detail and still continuing to digest, may I say, and certainly we are also finding extremely useful the temporary recognition regimes that you just mentioned there at the end, which has helped us quite significantly in terms of our planning. If I think back to where we started after the referendum in 2016. You know, I feel like we've come a long way on a long journey in terms of you know, moving our European business and sort of thinking about how we're going to reorganise ourselves after Brexit from a markets perspective, and in particular, you know, the first thing that we thought about on the 25th of June back in 2016 was whether or not, you know, that new provision in MiFIR might be useful to us, and we very quickly realised that we could not rely on that or avail ourselves or assume that we could avail ourselves of that exemption, and so we had quickly set to work to analyse, you know, our entire relationships with our EU clients and thinking about how we needed to recharacterise those. You know, a number of firms have set up significant EU subsidiaries or built out existing subsidiaries or existing branches in the EU, which recognises that loss of passport and the very different shift of connectivity to the EU that the UK previously enjoyed. And we have, you know, transferred clients. We've had to redocument a large number of clients. My firm and others also executed Part 7 transfers or court sanctioned schemes of arrangement in order to migrate a large number of clients across with as little impact on the clients as possible in terms of the repapering load, because of course, whilst Brexit, you know, can be all encompassing for us, there are a number of other regulatory obligations continuing at the moment, which requires us to continue to repaper clients for other reasons. And so, you know, we're very conscious to try and minimise for our clients the load on them. and we've, for the most part, really tried to focus on how we can continue to service our EU clients in the way that we do today, but with a slightly different lens on it. I think there are some challenges that still remain. We're talking about cliff edge risks. So where I think we have managed to resolve in many cases that the client servicing part of the loss of passporting, what I think the challenge that remains for firms at the moment is understanding how to maintain their intergroup positions, and from a capital and balance sheet perspective, and understanding what the new regime is going to look like from an intergroup perspective. And we still don't have clarity on that because we don't have the equivalence decisions yet on those. Also, we are still working through what I would term non-client relationships, but still requires movement of liquidity between global markets and the EU through London in the form of interdealer relationships and access to trading venues. Arvid mentioned earlier, in the absence of a MiFIR 47 equivalence decision, which could have resolved that small rump of interdealer and trading venue access issues in an aligned way, we now find ourselves looking to various national regimes and the patchwork that is there to understand how we can maintain that dealer and venue access to provide liquidity to our EU clients and access to the global markets for our EU clients, but also to provide our non-EU clients access into the EU as well, and to facilitate movement of capital there. And so, that's I would say remains an outstanding issue for us.
Perhaps if I can come in to what Rob said, I think it's absolutely right that the TPR does facilitate quite a lot, especially then when you look at other regimes, and the temporary permissions regime was always it feels set up to achieve the most that is really possible in terms of helping firms. And we've always certainly found that it is extremely helpful. And we shouldn't also forget that there's been a huge exercise on onshoring happening from the perspective of HMT, bringing pretty much the entire existing legal framework for financial services from the EU level into the UK legal framework. So obviously a lot of work went into that. And what we've seen recently from the FCA and also the PA and bank, of course, are a number of documents and consultations on the TPR, which really set out this in more detail. We've also seen some more detail on the use of the transitional powers, and I think maybe there might be some more in the pipeline as well. But obviously, we're not yet in December territory. So from an AFME perspective, it's awfully helpful to get all of this, and the more clarity that can be provided, the more helpful it really is. And I think that really does help EA firms who want to be active in the UK going forward. And then Caroline obviously focused on the firm level perspective, the issues that she's seeing day in, day out. What I would say from an AFME perspective is, and I kind of briefly mentioned that early on, is there are still some outstanding parts, especially on equivalence, where the share trading and derivatives obligation, I think, are probably the kind of number two issues after UK CCP equivalence. Now that's been solved. Obviously, it would be fantastic to get some more clarity on that. Perhaps data adequacy is also an important issue still for some firms in the market, and with the STO and the DTO, the Shan derivatives trading obligations, overlapping and conflicting trading obligations could make it really difficult for firms to navigate the environment, and at worst, this could also cause some market disruption. So from our perspective, equivalence is the most straightforward solution to all of this. Now with the STO, we've last year seen some clarification as well from AFME on limiting the scope of the STO. There might be some other avenues there to explore how this could be further limited if there should be an absence of equivalence. But as I really emphasize, the more clarity that can be provided in these coming months and weeks, the better it is, and the more helpful it will be for firms. And as we've been talking about equivalence, obviously data adequacy is in some ways quite similar. There has to be a technical assessment and also a publication of data adequacy if it does come to that. We've over the last few weeks seen the Schrems 2 judgment, which was obviously very important on standard contractual clauses, which a lot of firms have been using. We've just over the past couple of days, I think yesterday or the day before, seen that there has been another important judgment from the European Court of Justice with regards to the use of data and security. So this is something that might still play a huge role in some way, shape, or form going forward. And from a firm's perspective, obviously, the more clarity that you can get, and the earlier in the process, obviously we're already in October territory, but the earlier that is, the more helpful it will be.
And Arvid, that's very helpful. And that reference to data there, very important case. You just mentioned the Privacy International case, and I suspect that Vivienne in her session, whether she pre-recorded it before that decision, I'm not sure, but certainly one to watch. Now, I think Caroline Dawson from Clifford Chance has had one or two issues with the connection, hence me jumping in here. And I think at this stage of the panel, you're looking to move to thinking about the sort of the post-Brexit scenario and what firms would like to see from that future relationship, what the issues might be. This might not be quite the right order, but Caroline Boone, I wonder if I could ask you, what do you think, broadly UK firms would like to see from that future relationship?
Right. What we want to see from the future relationship, we just want everyone to get on, basically, don't we? That's what we really want. We want to be able to operate a seamless global model, to be able to interact with our clients and counterparties on a global basis with as much as possible. From the green room, I think. Apologies. We would like close cooperation with our EU partners as far as possible. I think we want to ensure that we maintain, and I'm sure that we will maintain, global standards across the board and uphold those and support those. As far as possible. I think that we thinking about the UK for a moment, I think we want to make sure that we are able to remain open for business. I don't think it would be helpful for firms to go to a balkanized model where there is localized financial regulatory constraints, meaning that we have a sort of a frictional booking or booking model. And I think that clients effectively do want to be able to source that liquidity globally. So we'd like to ensure that the financial services regulation sort of supports that model. I think there's a question now for the UK to think about how it formulates its financial policy and its future financial legislation. But I think that in the immediate term, it would be really helpful to just get through to the end of this year and perhaps have a period of time for reflection and a bit of a breather, because I think we have been through even if I think back to just before Brexit, we were sort of in the throes of quite an extensive amount of post-crisis regulatory reform, which we've also been running to implement for many years now. And then, we were just coming to a point in that, after, for example, the huge MiFID II overhaul, where we were sort of starting to get back in our stride. Then we've had Brexit, which has again been quite a large overhaul of how we operate. In the UK, we also had ring fencing reviews and reforms, and so we've undergone quite a significant structural reorganisation for a period of many years. And I think what we would like now is a little bit of continuity and a little bit of certainty for a period of time, whilst we take stock of the new order, as it were, reacquaint ourselves with our friends and regulators in Europe, and work out what's the best way forward to ensure that their concerns around are addressed, whilst at the same time our new position in and relationship with Europe is sort of recharacterized and hopefully affirmed in a positive way.
Well, thank you, Karen. That idea of a sort of little bit of a period of reflection sounds like it's like an excellent one to me. Of course, the European Commission in particular is always keen on new initiatives, on whether it's on ESG or digital finance or AML or many other things in its plan. So as always, we've got issues that we'd like to reflect on, and then there's always some new ones coming through. I wonder, Rob, obviously limited to what you can say around the sort of the post-Brexit landscape, but I think you were going to comment a little bit on the existing Treasury communication and proposals around implementation of CRR2, CRD5, BRRD2, if that's possible.
I think I was probably going to more focus on actually just the point Caroline mentioned about the pause. So I think, absolutely echoing that point she made, that I mean, there's been a very large amount of work that has had to be done about moving the huge body of European law into a domestic regime. That has involved an awful lot of amendments by the Treasury to pieces of UK legislation, but also bringing on European regulations into UK law with the necessary amendments to reflect the fact we're no longer in the EU. There's been a parallel operation by the regulators to deal with their rules and the binding technical standards under the regulations. But I think really the thing I just wanted to focus on is if you haven't caught up with them, the temporary transitional powers. So each of the bank, the PRA and the FCA have issued directions. And what these are intended to do is really, as far as we can, give firms continuity at the end of the transitional period, generally for a period of 15 months. There are a few points that are accepted from that, and there are a few that work from a shorter period, but they're important to look at. So in many cases, in fact, in most cases, firms will be operating the same regime they had before. And the way the directions are relatively unusual. They look at the outcome. So rather than going through every single rule and saying how it applies differently, what they effectively say is, if you're looking at a new rule that has been brought in as part of the onshoring, the general position is that if that didn't apply to you before the end of the transitional period, that won't apply to you for that transitional period. And then if you're looking at a rule that the way it's applied to you has changed, so to give you an example, currently firms can apply the same capital and liquidity treatment to EU exposures as they do to UK. They will be able to continue as though that hadn't changed, and only at the end of the transitional period will they have to treat other EU countries as though they were on the same basis as, say, an American or Swiss exposure. As I say, though, it's important to check the detail. There are some exceptions, particularly around contractual stays and bail-in, and just picking up on what I said earlier in relation to compensation. The final thing I'd say, and this is probably the one point I can make about future changes, which obviously we'll have to look and see what comes on those over the coming weeks and months, is that arrangement only operates at the end of the transitional period. So we can apply transitional directions to the law as it stood at the end of this year, or at the end of it stands. When new changes come in, and you've touched on some of the key changes that will be coming, we will have to look at the question of how they transition on a case-by-case basis. So that will be one to pick up as material becomes available on those.
Rob, thank you. That's great. Now I'm hearing that we may have Caroline Dawson back. Do we have Caroline Dawson? Super.
Yes, I'm
Caroline.
Brilliant. Thanks, Richard. Yeah, perfect. No, thanks very much for that, Rob. And obviously, so I think that there is a huge amount going on for firms really at the moment, isn't there? So you've got all of the onshoring changes to European legislation. You've got the temporary transitional powers. You've got the fact that you've got the interplay between the PRA and the FCA regimes. And then on top of that, obviously, people are thinking about their cross-border business as well, not just their UK business. So maybe, coming back to Caroline, that there is a huge amount for firms to do to be ready for day one. I suppose, what do you think? Where do you think some of the key challenges lie? What are you most concerned about?
Yeah, so we started talking about at the beginning about what have firms done to prepare, and then at the end of that, that there are still some cliff edge risks, which we also talked about in the form of interdealer relationships and access to trading venues and our intergroup position. But there are also some challenges around just getting ready for the new UK regime, and then understanding how the EU regime, the existing regime, applies to our client base and to ourselves. And so, whilst everything that the Bank of England and the FCA has put out thus far has been incredibly helpful, we do still have some quite large open questions in relation to the outstanding equivalence decisions, which impacts quite significantly on how firms operate. And and to be specific, the sort of tech build that we'll need to put in place, and the client conversations that we need to have to get our clients ready and to get ourselves ready for the new regime. And we're not able to do that at the moment because we don't have that certainty on those equivalence decisions. And specifically, Arved mentioned earlier the challenges around the STO and the DTO, and I would add to that the characterisation of counterparties under EMIR. We want to be able to make this transition as smooth for our clients as possible. And as we are now it feels like we're galloping towards the 31st of December, it's going to be a sort of crunch period this autumn, come winter time, when we're going to be doing some quite having to do some quite sort of significant, potentially, communications with clients right at the last minute, because we haven't got this certainty on those outstanding equivalence decisions, and that is making it a little bit challenging there. Related to the SI, there's been a huge amount put out, and we have obviously been looking at those since last year when they were released, and thinking about how we need to implement those in order to be ready for day one. You mentioned also, Arved, data adequacy. That's something that's really important to us. I mean, obviously, while we were waiting for Schrems, the Schrems judgment to happen, we did sort of spend quite a lot of time focusing on those standard contractual clauses. Obviously, that is not a complete and an entire solution, and there's some daylight there. As far as possible, we want to try and kind of ensure that we are, fully compliant where we need to be, and data adequacy would really help us with that. So that's just a sort of bit of a gallop through some of our kind of sort of day-to-day technical challenges, really.
Yeah. Brilliant. Thanks very much. And I suppose, Arved, I know obviously AFME's been doing a lot of work in terms of monitoring some of these equivalence decisions, monitoring the third country regimes that different member states are introducing, and just trying to help the industry prepare a little bit that way. I suppose in terms of helping to prepare for those day one challenges, I suppose, is there a role for industry associations? Do you think that does AFME have plans to help in other ways?
Yeah, absolutely, and I think that's what we've tried to do over the past years. And I've been in this role for 2.5 years or so, and it's been quite the ride. And as Caroline Boone was saying, we're really galloping towards the end of the year now. At the moment, as I kind of laid out earlier, there's a lot of focus on the national regime, so we're doing a lot on that with members, trying to understand exactly how they work, and where we can be most helpful as an industry association. And I know that our association peers, across Europe, but also obviously in the UK, are all looking at this. So at every level, I think industry is really trying to prepare. And then there's, of course, the big question, what comes after the 1st of January in terms of the future relationship. I think it is clear that Brexit will have an effect on financial markets. We all know that. What we probably don't know is when exactly those changes will all be materializing. I think it's probably something of a longer term horizon, even that we need to look at maybe the next 10, 15 years or so, which might, where we can see some changes over that time period, maybe even longer. Caroline Boone was saying, a lot of firms are setting up their presence, or even in plural, different presences across Europe, not just in one location, but in many. So it's clear that Brexit clearly has important implications for financial markets, and there's obviously also a role for industry associations and AFME to play on that side. When we think about, for example, how will this affect CMU going forward? I thought it was, from an AFME perspective, I guess we approach this as we support closed and interconnected markets. From our perspective, capital markets are global. They do work across borders. And it was interesting then in that regard to see the CMU action plan published recently, where on the one hand, it's the EU states that it's important that the EU develops its own critical market infrastructures, but at the same time also has to remain open to global financial markets. And in the same vein, we saw the concept being kind of introduced there of open strategic autonomy, what the EU wants to achieve. And I think if you look at that, there's probably a word in there for everyone: open for some, strategic for others, and autonomy, I'm sure, will be the word for some as well. So whichever side of the fence you sit on. So it will be really important to see how that will pan out in the future, how that will be applied in the future, and I'm sure AFME will always take a stance there to call for integrated markets, and highlight that international investors, firms headquartered outside of the EU, obviously also have an important role to play within the EU to facilitate investments and growth. And I think within that process, obviously, equivalence becomes extremely important. It already is a very well used third country access regime, but we will have to see how effective it can be then going forward. We put out a paper earlier this year, not in a Brexit context, but more in a broad third country context, how equivalence can be further improved, how it can be made a bit more certain, give a bit more transparency to market participants, because I think that is what is really needed at this time and at any time of change. So I guess with Brexit in mind, we'll be calling to minimize fragmentation as much as it is possible. We think that this will really enable users of financial markets to finance growth, but also to manage their own risks as effectively as they can. That's especially important, of course, in times of COVID, but it will also be important going forward, once we're hopefully beyond COVID at some point. And with that in mind, we really do hope that the EU and the UK establish a close, a cooperative, and also a stable long-term relationship. We support continued consistency of approach for financial services regulation going forward. and with the next kind of weeks in mind rather than years, as I've kind of mentioned, it's really important now to have more clarity on equivalence, to put in place close supervisory cooperation mechanisms to have efficient oversight, but also ideally to have some sort of formalized framework for regulatory cooperation. I think that will be really, really important, and it will help to build trust. It will help to establish that positive relationship. And while perhaps a lot of the noise that we do get day in, day out on Brexit is around how limited the FTA might be, how limited it might be on financial services, I think a deal is very important. It can really help to build a positive relationship, and we do need to build on that going forward, and not just for the next few months, but probably for the next 10 to 15 years or so.
Yeah, and I suppose just looking at the long-term relationship then, so we have got a couple of questions on Slido. One around the likelihood of an FTA and how helpful it might be, and then and then a second one around the likelihood of the UK making its own equivalence decisions in relation to third countries and when those might happen. I mean, maybe just to start with looking at how helpful an agreement on how helpful a free trade agreement might be. I mean, I suppose if you look at the existing EU free trade agreements and have a look at what they provide for on financial services, I mean, probably the easiest way to sum that up is not a lot. We're starting to see free trade agreements which have separate dedicated financial services chapters, but that is a fairly recent development. So, I suppose if you look at what they typically provide on financial services, you're really looking at more around some kind of agreement towards agreeing, essentially. So it's really a framework for future discussions. I think probably the strongest commitment that tends to be given is around provision of services in the relevant jurisdiction, where essentially typically you see people committing to national treatment. And what that really means is essentially that, so if you're talking about, let's say, UK, Canada, or EU, Canada, what you're saying by committing to national treatment is saying that if you provide services in Canada, then you will be subject to treat the same national treatment that a Canadian bank or a Canadian investment firm would be subject to. So that's not really anything approaching the existing flexibility and the passporting, cross-border passporting arrangements that we've got today. It's really saying, you do business in our jurisdiction, you subject yourself to licensing regimes in our jurisdiction. I mean, in terms of what the UK and the EU are looking for their financial services commitments, I think we can see, it is building on existing free trade agreements. I think Japan being the most recent and the most extensive, but even then, it's not going to come close to replicating the passport regime. And then in terms of equivalence decisions, I mean, I think, the EU's been pretty clear in terms of the equivalence decisions that it's planning on giving short-term, medium-term, long-term. There was a reasonable list of equivalence decisions that they were not planning to give in the medium to long term, and then an even longer list of equivalence decisions that just weren't mentioned at all. I suppose maybe Arvid, back to you. I mean, what would you see in terms of the future relationship, in terms of availability of a free trade arrangement, and how useful that might be? And do you have any thoughts on particularly actually where the UK might go with equivalence?
Two very good questions there, I think. So on the FTA, and I very briefly mentioned this, I think generally from what we hear in the media, obviously I think all of us would quite like to sit in the room when Frost and Barnier meet, but we're not there, or to be a fly on the wall. But it does appear to be relatively limited. What of course we have seen are the draft FTAs from the EU and the UK being published. I think the UK one does go a bit further, trying to set up some more institutionalized cooperation, also maybe bring something around equivalence into the mix. I'm not sure if that will be the point where we end up with an FTA, if there is one. The EU's one is certainly a bit more closely styled to Caroline Dawson, what you mentioned in terms of very, very limited. You can't even call it access provisions, but there are some ways of treating each other fairly. So we will not have any kind of silver bullet with the FTA. That is very clear. But as I said, I think an FTA generally is a way to achieve a positive long-term relationship, and you can always build on that. And at the moment, we do see a patchwork with national regimes, but this will be a very long-term development. And I think if we do have something to build on, that is a positive step. On the UK's equivalence, from what I understand, the UK authorities are very busy looking at that. I haven't seen anything published yet, but I'm sure there would be some announcement at some point, and I would be fairly hopeful that we will see positive equivalence determinations from the UK to other third countries. Now, obviously, for the UK, the EU will also be a third country. I think that will always be a special relationship in terms of equivalence. It almost goes both ways, but hopefully we will see an announcement on that side.
Yeah, I mean, from the UK side, it's a bit of an odd one because equivalence isn't really an approach that the UK, has developed domestically itself. It is very much an EU inherited concept. So I think it will be really interesting to see what the UK makes of those equivalence decision powers. And actually maybe whether in the longer term we end up with amendments to the relevant legislation, maybe moving away from those equivalence decisions and possibly more towards something that is more traditionally in line with the UK's approach to cross-border services. Rob, obviously I'm not asking you to comment because I know you can't. Caroline, I suppose maybe any final thoughts from you on whether a free trade agreement would be something, is that something that you consider important? Is it something that that you're hoping for, or is it essentially, given where we are in the proceedings, it's kind of anything we could get out of that is a positive, but you're not really relying on it at all?
Well, I think banks have had to plan for a no-deal Brexit, and I think relying on any form of deal is something that we have had to put to one side. But I think that, of course, when we are now turning to thinking about our longer-term future, and rather than perhaps calling this the beginning of the end, maybe we should call it the end of the beginning, because we are really just beginning now. And I think a free trade agreement on financial services would of course be a really useful starting point for that new relationship and working through the future regulatory cooperation and strong relationship. Caroline seems to have changed into somebody else. So shall I hand back to you, Richard?
Yeah, thanks very much. And I'm just looking at the time. I think we're just about up to our allotted time anyway. So a big thank you to Caroline, Arvid, and Rob for that session. Whether it's the beginning of the end, it strikes me from the discussion there's an awful long way to go in terms of free trade agreements, future equivalence decisions, whether that's EU to UK, UK to other countries, the Schrems case and all the implications for data transfers as well needs to be sort of worked through. So a long way to go, I think, on all of that. So we'll now be going to a short networking break, and I think we'll be back in about 15 minutes for the first session around trends in conduct and culture. So hopefully see you back for that. Thank you.
Good morning, everyone, and welcome back from the coffee break. I hope that you've had an opportunity to network and visit the virtual booths. I'm very pleased to announce the next session of the day. It's moderated by Stephen Stromberlin, Managing Director at Capital Forensics, and the theme is New Trends in Conduct and Culture. I'm personally very interested in this topic, and I think it's going to be a thrilling discussion. Stephen, over to you.
Thank you, Louise, and it's a pleasure to be back with everybody, and I look forward to next year when we can all be together in person. Firm culture has a profound influence on how a financial institution conducts its business. A culture that consistently places ethical considerations and client interests at the center of a business decisions helps protect investors and the integrity of the markets. Conversely, failures in these areas can impose significant harm on investors and markets, as well as the firms themselves. One estimate places fines and litigation costs to firms or their parent companies related to cultural failures alone into the hundreds of billions in the past decade. This underscores the critical importance of firms establishing and implementing strong cultural values. Regulators throughout the world have examined very closely how firms establish, communicate, and implement cultural values and whether such values are guiding business conduct. But much like the compliance vocation itself, assessing a corporate culture and promoting an ethical business environment is more an art than a science. Today, we've assembled a distinguished group of compliance and regulatory artists that will help us over the next 45 minutes explore the science of conduct and culture. As Louise alluded to, I'm Stephen Stromboline, broadcasting from the United States, so I have my caffeine just in case, as it's quite early here. I'm joined by Alessandro Chiozzi, who is the head of European Wholesale Bank Supervision for the FCA, Anthony Whitehouse, UK Head of Compliance for Natixis, and Leslie Coombs, Compliance and Operational Risk Control and Investment Banking Head of Conduct Risk Framework for UBS. Alessandro, the FCA's 5 conduct question program is now 5 years old. We had the most recent report come out last month. Messages from the engine room, I believe, is the moniker. Why don't we use that as a foundation for our discussion today? Can you bring us the FCA's opinions and observations to life a little bit for us?
Sure. Thank you very much, Stephen. As you said, at the beginning of last year, almost 4 years since we originally launched our 5 conduct questions, we sat down to brainstorm on how to take the program forward. After 3 years of meetings with CEOs and heads of business at the largest banks, we had reached a stage where we could have guessed exactly what we were going to hear at the next meeting, and we were at the point of diminishing returns, really. The idea we came up with was then to drill deeper, to take a temperature check of the firm's engine rooms, as you mentioned, and as we defined it. To do this, we hosted 18 roundtables with an equivalent number of banks, inviting 10 staff at VP level or equivalent from each firm. When we started, we didn't know how much we would get out of it, but at the end of the year, we were really pleased with what we had learned. So what did we find? I think it's important to say that in many cases, we were quite happy with what we heard. The bank's staff that joined our roundtables were open and willing to discuss even delicate topics. Most of them acknowledged how things had changed since they started, and in many cases we're talking about people with like 5 to 10 years experience. And undoubtedly firms had made progresses in the last 5 and 10 years. The senior managers and certification regime, the changes to remuneration policies, the firm's investments in their conduct programs, and in staff training, all of those things have had a significant impact, and we recognize that. However, we also found that a lot more needs to be done. I really invite everyone that is listening to our webinar to have a look at the report if they haven't done it yet. But if you only take away 3 points, let it be the following. First, help your staff think about conduct risk as broadly as possible. In our meetings, individuals often describe the conduct risks in a worryingly narrow way, and they were often only really familiar with the most obvious risk for their own role, like management of inside information in M&A, for example. Second, continue to challenge your remuneration and promotion processes. Seeing peers or more senior colleagues that are not known for being conduct champions, let's put it that way, being promoted, make staff feel that their contribution to the P&L may offset a less than optimal behavior. And we heard that over and over again in our roundtables. Third, what we called the tone from within. We know how important the tone from the top is, and our intention with this report was not to downplay that. But we also stressed the importance of empowering everyone at all levels across all of the 3 lines of defense to contribute to identify and manage risks. So overall for us, it was a really, really interesting exercise. We really enjoyed it. We think we learned a lot. And I hope the people that read our report also found it helpful.
Thank you, Alessandro. I guess the flip side of that is the firm's view of things. Anthony, any views from your side?
Yeah, I think that there would be no firm which would turn around, look at the FCA work in relation to the 5 conduct questions and say, not useful, not relevant for us, and we're going to ignore it. So, not least because there have probably been some sort of enforcement action. But aside from that, it is extremely useful, and there are quite a few jurisdictions around the world which look to the FCA to set the standard in relation to a number of things, not least conduct and culture. AFME is a European organisation. Most of the banks that are present here have global presences. So it's not just the FCA which is looking at this type of thing. For example, you have senior managers regimes that have been adopted in Hong Kong and Australia. And in Hong Kong, you've got the manager in charge regime, which is a little bit like the senior managers regime here. In Australia, you've got the banking executives accountability regime. And these are all drivers for cultural change through greater individual responsibility, which are probably lagging to a certain extent the work that the FCA has been doing with both the senior managers and the 5 conduct questions. But it's all about creating the same change. I mean, closer to home as well, from a European point of view, there has been perhaps a little bit more interest in personal accountability as opposed to overall firm accountability. But also there have been quite a few European regulators that have been looking at selling practices and culture within firms to see whether it really delivers the right outcome for the clients in their jurisdictions. Most banks, I think, in Europe have issued codes of conduct now. So that's firmly embedded in what firms are doing. Most of the firms that I know, particularly the French firms, SocGen, BNP Paribas, my own firm, have implemented culture and conduct programs, and to a greater or lesser extent will use things like the FCA's 5 conduct questions as things that they can learn from and build into their own conduct programs. So I think, yeah, all in all, what the FCA has done in the UK in relation to conduct and 5 conduct questions is great for us as the UK part of the organisation, but also elements of that are, as you can see, seeping into overseas jurisdictions.
Thank you, Anthony. It's quite a challenge. You can't argue with the concept that every firm should have an ethical culture and a conduct that's appropriate. Much more difficult to accomplish that and to account for it, surely. In the United States, I've seen the same thing with regulators and firms, global firms, who are implementing many different elements. But it's a slow process, even though it's been a topic that's been discussed now for a half a dozen years for sure, probably longer. Leslie, over the last year or so, let's go back maybe beyond that, what has really changed in a firm's culture mindset? How is that being demonstrated and communicated at global firms such as UBS?
So what I see is almost, look at what the title of this is, New Trends in Conduct and Culture. And I think there was a time where you might just see conduct, or you might have a focus on conduct risk. We had conduct risk forums. And now I have really seen that there's more conversation about culture, and that the two, you need to talk about them together, and you can't really talk about them in silos. And that you have, even with people's responsibilities, they now have a conduct and culture responsibility rather than just a conduct responsibility. And it also goes back to starting to talk about the positives that happen. Is I think with conduct risks, there was a lot of focus on what goes wrong in an organization rather than from a culture perspective, what's great about your organization, what makes your organization sometimes avoid some of these conduct risk pitfalls, and placing more focus there. So I see that as a direction of travel that a new mindset, that you really have to look at the culture of your organization if you're going to see the right kind of conduct.
Excellent point. Alessandro, I know the FCA has had an overview, which is quite helpful when you're looking at many different firms and getting feedback from many different institutions, surely focusing at least in the 5 years that I spoke about with the program, but even beyond that, what has really changed in the culture? How have you seen it evolve in that time?
So I think as you were saying, this is not like a sprint. Like looking just a year ago, it's difficult to see the change. But when you step back and you look at the 5 years or 7, 10 years, probably a lot has changed. And I'll use a little example again taken from our engagement with staff at VP level for our 5 conduct question last year. We met with 10 staff from one firm that of course I won't mention, and we were pretty pleased with what we were hearing throughout the discussion. We thought that all of the individuals were participating a lot, were very engaged, were saying all of the right things. Then we get to a point where we ask them, so what do you think about your firm's conduct program? And they all go blank. And they look around, and someone started talking about training, and they're not sure what they were talking about, what we were asking them. And the first reaction was a bit like, how is that possible? But actually, on reflection, we found that quite good. We thought, these people have not been instructed to think about the conduct program as something that is separate from everything else. They have a mindset where they think about things in a way that is pretty similar from what we would like to see, but without this specific framework of the 5 conduct questions or the conduct program, and outside of that it's like the business. So we are actually pretty pleased, and we would like to see more of that. We hope that we will see more of that going forward.
I also,
Thank
just
you.
to echo on that, just to come kind of add a little bit onto that, is when you say, please join us for our conduct risk training versus, you lose sometimes people because they're like, I think I've heard that before. So we also have been trying, working on having, just events that touch upon conduct and culture, but they don't have to be named that. They don't have to, I think that's a real, you get a wider, I think, attendance when you stop trying to use, these monikers as you mentioned earlier.
Yeah, I agree.
It's a-
Embedding conduct means making it part of everything that we do and everything that all staff do, rather than a discrete piece of training or something.
I think when you get to a point where your employees are not thinking about it, it's just how they react, it's how they are, then you've gotten to a good point. It's hard to get there, also hard to know when you've gotten there. We'll talk more about how we measure conduct in a little while. Obviously, this past year has been a tremendous challenge with COVID. Our industry has had a variety of challenges throughout the years. We surely could list them out. It would be a very long list, but we've not seen anything like COVID and all the working remotely in that regard. So Leslie, back to you in terms of how has COVID provided challenges, maybe opportunities for changing and reassessing, and with the remote working especially, what's working, what isn't working?
One of our senior leaders, I think, said it, very well, which is that COVID has just really accelerated and intensified the inevitable, which is flexible working, and which is caused us to have to, accelerate some of our plans in terms of investment in technology, making it, very feasible for a large percentage of the workforce to work from home. So I think if we could all imagine that at some point we would have more people working from home, maybe, but not in necessarily this context. So I think COVID has, in a way, provided us, trying to look on the bright side of something that's been devastating, the opportunity to move us further along in that journey a little bit faster. That being said, I do think there is something about being together. Even in this context, it's lovely to be able to at least to see your faces. But I think it does create a whole different experience to be in a room together. And so how do you start? Does the culture start to get eroded potentially if this is the only contact we ever have. And also you can imagine the challenges with supervision or remote supervision and staying in contact on a regular basis. If I have a huge problem while I'm sitting at my desk, you might actually hear, like me go, oh my goodness, and that might, lead to someone next to me going, oh, do you need help? When that happens in the confine of my home office, um, you know, there's no one reaching over to say, hey, you need help with that. And then there's me looking to see, is anybody that can help me online, or do I just try to figure it out myself? And I think you start to maybe lose some community. And another point that we've been talking about is when you have teams, there's also the risk that maybe 5 people are in the office and 5 people are not. And as you can imagine, I think we've all experienced it when you've been on a conference call and the majority of the people are in the room and you're on the call trying to interject yourself into the conversation. And so do you start to develop silos even within teams? So, not even talking about the wider company, but within even those teams, is there, more potential for the people who are coming into the office? And, and then you start to have a real conduct risk there as well.
Leslie, did you have to make certain put in compensating controls for things that would be very difficult? Like I think of mobile phone rules that you'd say you couldn't use a mobile phone off the trading floor to speak to a client. You'd have to be on a tape line, all of that. I'm sure UBS instituted a lot of different directives on what employees needed to do, what they couldn't do. How did you address that?
Well, that one specifically, I don't have the answer for you, but I can say that over the course of COVID, and I think this is the case for a lot of firms, and talking on industry calls, we have had to rely upon a lot of the good work, hard work that we've done in the past around educating, promoting, reminding people about the importance of doing the right thing. Because in this environment, you don't necessarily have the same level of monitoring in place, for example, for your mobile phone, right? So we we have to put a lot more reliance on that people are going to do the right thing. And so far, yeah, it's working. So I think like it's almost like you teach you teach someone that these are the rules of the road, and not only the rules of the road, but this is the judgment you should use along the way. And when they get out there and they start driving, you don't necessarily have the rule book sitting right next to you, but you expect them to rely upon all the things they've learned previously. And I think there's a lot of reliance right now on that.
Very important. Alessandro, I'm going to ask you in a second about your view and what you've seen at different firms, and are all firms meeting the right standard? Because I know most of the global firms that have the access to funding have done things quite quickly. It's been quite surprising, but when I speak to certain clients that are smaller and don't have the same access to budgets or technology, they've been a little bit slow to get to where they need to. So what have you seen overall with the variety of firms that are under the purview of the FCA?
So I think from an IT and operational resilience perspective, this has been like a huge stress test, like a real life stress test that generally has worked relatively well for the markets as a whole. Even at the peak of the pandemic, even when people were forced to go and work from home with like very, very little notice, and obviously it's for something that was unpredictable, markets continue to work relatively well, especially from an operational resilience perspective. I would also echo some of the points that Leslie made about the importance of the work that firms would have done before, and how this is really a good example of how culture is not just something that you want to develop to please your regulator, but it can really translate into a commercial advantage. And I can really see how firms that had done that homework in terms of training of their people, in terms of creating a healthy culture, can now reap the benefits in a situation where obviously you don't have the benefits of face-to-face supervision, and controlling what your staff do is very, very challenging. Another example, I guess, is onboarding new staff. And I think firms that have a strong and healthy culture, although they will find it challenging, it will be challenging for all of us when we have to onboard new staff in this environment. But it will be definitely more difficult for firms that don't have developed a strong culture to help those people to amalgamate and blend in a new organization in this environment. So I think it's really like testing how firms are able, to collaborate, to create a safe environment where people can speak up, continue to provide the platform for people to, break the silos, collaborate with each other, and so on. Very, very difficult, but I really think that culture plays an important role in this.
Thank you. I'd like to turn to one of the Slido questions that has come in, and I encourage everybody viewing in to add your questions to Slido. This one, I think, more for either Anthony or Leslie. The question is, have you adjusted your conduct red flags for a remote working environment? And if so, what risks have been highlighted for increased focus?
I'm not sure what's meant by conduct red flags, but I think one of the areas of heightened risk is the supervision piece. I mean, when we were in the office and you had a remote supervision responsibility, that's an area where you have an increased potential for risk. So I would say that is a continued area of focus in terms of how do we ensure that our supervisors are well equipped in this environment, and giving them checklists, tools, etc., to help them continue to be effective supervisors.
I'd probably echo what Leslie says. I don't think that firms have been changing set parameters that they would have as red flags in relation to conduct. But COVID has certainly changed the environment that people are working in. And whilst to a large extent, and it depends on the firm, probably the technical environment hasn't changed very much. You may have already had the ability to work remotely. You may already have your IT set up to allow the recording of information that's required, the monitoring of that information, wherever people are based. What's obviously different with COVID is the fact that people are completely separate. There is no group, or is less group working now, and there is less of that individual ability to supervise teams, look over people's shoulders, see what's going on. So I think instead of changing the red flags, what a lot of firms will be doing is trying to equip their supervisors, their managers, with the ability to cope with this remote supervision, giving them ideas about what kind of things that they should look for, whether it's from a conduct point of view or simply from a normal duty of care point of view that banks have for people's health and well-being, because sometimes conduct issues arise because of problems that individual members of staff have. So if you can prevent those problems occurring, to a certain extent, you'll prevent some conduct issues occurring. So it's not putting in place different red flags. It is looking at the environment and seeing how to adapt to that environment better.
Thank you, Anthony. And I'd like to stay with you, but also open up this question in a moment to Leslie and then Alessandro as well. And I think that is when a regulator speaks to senior management, somewhere in that discussion with conduct and culture, they ask, how's the culture in your firm? And the answer usually is excellent. I feel very comfortable. I can sleep at night. Things are moving well in that area. And the second follow-up question is, well, how do you know? How do you measure it? So I think the most difficult question that all of us in the compliance vocation, the regulatory vocation, have to answer is, how is a firm's culture actually measured? What means do we measure it? whether it's surveys or hotlines or measuring different types of behaviors, or what measurements may be in place. Are there self-assessments, scorecards, things like that? At the end of the day, when the regulator asks the question, how do you give them a specific answer that you can back up with data, if you will? So Anthony, maybe I'll start with you and then turn to Leslie, and then they'd be very interested in Alessandro's view as the regulator.
Thanks, Steve, for always the difficult questions. I think that conduct is really difficult to measure and get to the bottom of. I was trying to think of a useful analogy to describe conduct and the difficulty in terms of measuring it. And it's probably like the air that we breathe. You can generally smell when something's rotten and doesn't smell right. You can also probably on a nice spring day smell something sweet in the air. But to try and measure it, grip it, grasp it, it's very difficult. I've been involved in a number of conduct and culture programs at different firms over the past few years, and I don't think anyone has come up with a foolproof and objective way of measuring culture. Most of those firms will have organised staff workshops, had all kinds of different feedback fora, whether it is anonymous post boxes, the ability to write on posters on the wall, to send emails, whatever it might be. What I find is that quite a lot of these will develop into general complaint sessions unless they're well controlled. But it's also easy for those people receiving the information to manipulate the findings to deliver a view of culture that they want reflected. So these aren't as objective as they possibly could be. I think what they do though, is to achieve a greater awareness amongst staff about the fact that culture is important and the link to conduct. And by all these different types of conduct program workshops, fora, you tend to engage with staff at all levels. So that's good coming out of it. But whether you can achieve a measurement of conduct or culture, difficult. You've also got things like pulse surveys, which you can send out with any frequency you want. I think that our firm was doing pulse surveys on certainly a monthly basis at the start of COVID to see how staff were reacting to lockdown. And these can give you a snapshot of what a firm is like in terms of its culture at a point in time. They can be very short or very long, depending on how you design them. But again, depending on how you design the questions, will show you what answers you get, and the results can be like opinion polls, manipulated to a certain extent. So it may not be as objective as you possibly think. A lot of firms will have basic information already, basic management information, MI, but this tends, in my experience, to focus on the negative aspects of a culture or conduct, and tends to focus on individual conduct, rather than maybe wider area or firm conduct or culture. So you have things like indicators of compliance or risk breaches, the number of these, the severity of these. But again, these probably don't give you a useful picture of conduct or culture in general, and aren't anything that you can use, I don't believe, to test the overall culture of a firm. There's also, I think, a danger that by having a concentration on that type of MI, you can even drive culture in the wrong direction by focusing on punishing any wrongdoing and any infringements. And what you potentially then do is to drive the culture into one of hiding errors rather than speaking up. So it's quite difficult in terms of identifying what MI you can present and how you want to deal with things like breaches. Obviously, firms want people to self-report as part of an open culture if they've done something wrong. But if you're going to be punishing the failures for self-reporting, then you may get the wrong outcomes. Same thing is true with whistleblowing. And I remember having discussions probably with Alessandro at meetings in the past about whether a good culture is reflected by very low levels of whistleblowing because there are no issues to report, or whether that's actually an evidence of poor culture because people are afraid of speaking up. and it's really difficult to know what that means. You can, in terms of measuring culture, again, you can have things like exit interviews for people who are leaving the organization, where they are probably going to be freer about speaking up. But again, these can also be situations which can lead to people airing grievances, bringing out long-standing grudges they've had. So you have to judge whether the information you're getting about the conduct and culture in the organization is really accurate or not. So that's kind of a fairly negative picture in terms of, I think, how difficult it is to measure culture. And I think that my observations are, from most of the firms that I've looked at, they tend to measure culture around individual behavior. And I think the one thing that firms need to start thinking about going forward is how you measure culture because of the firm's behavior, the institutional behavior that firms have. So institutional failures in a particular area, which may not be able to be attributed to any one individual. That's still a problem in relation to culture. That can still lead to conduct failures. And somehow firms need to have greater oversight and reporting of those institutional failures as opposed to the individual conduct failures. So things like an issue occurs, how quickly is it remediated, how seriously was the issue treated, are the issues recurring, even if you can't pin it down and say, well, it was that person who's responsible and we're going to punish them for it. If you can get all of these different bits of MI, then like the kind of pixelated paintings where you have lots of dots that make up the whole picture, probably you might call it pointillism in the kind of expressionist terms, you may be able to build up a picture of what culture is like in a firm. But you would need many, many data points to be able to do that and have a picture that looks something like the Mona Lisa, as opposed to just a scattering of dots on a page and an outline at best. And I think, for me, what I've seen across many, many different firms and from the discussions that I've had with other people in the industry is it's still a work in progress. And this is probably the next big area for firms to work on, how they can have a much more objective means of establishing culture, because it's the culture that drives conduct. So I'm not sure I've helped terribly much there, Steve, but those are my views on culture and measurement.
No, I think that was excellent. Before I turn to Leslie, first of all, I think you actually hit on some of the Slido questions that have come up. You've answered them without even knowing that the question was there, on dashboards and things such as that, people leaving the firm. And I'm not sure if this is a question for you or for Leslie or even Alessandro, but one of the questions which fits into what you were talking about before with hotlines is, do you think that the directive on whistleblowing will be a game changer, a catalyst in the improvement of conduct? I'll open up that to anyone. If no one has.
So I think that in terms of the whistleblowing directive, it just puts a little bit more framework around what firms should be doing already. I think for us, some of the changes were relatively minor in terms of the speed of response and how you have to respond to whistleblowers, because the basic requirements for whistleblowing were in place beforehand. So I'm not sure that the directive changes much unless you didn't have a whistleblowing program in place already, which means you probably weren't compliant with UK legislation. You probably weren't compliant with the expectations of the FCA if you're a UK firm. And many other firms, many other countries will have had these sort of requirements in place already. So it's just formalizing what these requirements would be.
Excellent, excellent. Leslie, we can turn to you. Your thoughts in terms of the measuring of the culture and the metrics, the specifics, how hard that part of the science is.
Yeah, I agree with Anthony. It's not an easy trick, right? If I heard someone say one time, if you could just limit, like, few points of how to say, do you have a good culture or not? They talked about retention, creativity, and innovation. And I really like those because they're pretty easy to see. If people want to continue working for you, people seek out to work for you. If people feel, I think there's a certain level of freedom that comes from feeling creative, and you feel like you're in an environment where if you have an opinion, that you will be heard. And innovation, I think, creativity and innovation, I think, go hand in hand. I think that gives you an idea of your culture at a very, very high, very high level. And I think it also says a lot when people leave and they come back even about the culture of your organization. So, and I know that is part of, we look at some of that MI as well. But to Anthony's point as well, that there's so many different pieces. And I think it's also the continuously looking at those different ones to inform you of a potential story. And I think maybe we'll never get to the point where we can say, this is our culture, like we can name it by looking at all this different MI. But I think what you will be able to do is identify where you're doing things maybe well and where you maybe need to make some changes. And if you're constantly looking at these potential measures, I think you'll see a growth in your program, for lack of a better word.
Excellent. Alessandro, thoughts?
I think that makes sense, and I've heard a lot of things that I can relate to. I think it's very important to, even before starting to discuss how we measure culture, for each firm, for each bank to define what like a healthy culture is for their own organization. Because obviously that will then drive how you try to measure those things. Leslie gave an example. Healthy culture can be defined by people wanting to work for that company. So how do you measure that? And once you actually come up with your own definition of what a healthy culture is, it becomes easier to try to find some data points, some MI that you can put in place to come up with your own measurements. Then, we as a regulator, we would never go to a firm and we would never tell them, oh, we think you are a 7 out of 10 in terms of culture. We would never mandate how to measure culture either. But we do think that, healthy culture generally has some, specific characteristics. A healthy culture has to be purposeful. It has to be safe and allow people to speak up. Even outside of the whistleblowing processes. The whistleblowing process should be a last resort, but people should generally feel free to speak up in the course of the business, to raise issues with their managers, with their head of division and so on. A healthy culture is diverse and facilitate and promote diverse thinking. And this is why we as a regulator care about things like non-financial misconduct or bullism, because they give an indication that people don't feel safe to speak up. And so they can provide an indication of something that is not healthy with the culture of the firm. Also, that's why for us as regulator, D&I matters, because it fosters diversity of thought and helps prevent risks linked to group thinking.
Thank you. We're just approaching the final 5 minutes, so we have a few topics to get to. So I'll just ask the panelists to kind of focus your answers very specifically, and let's say 1 minute time. So it's a little bit like the political debates. We'll give you 1 minute and a rebuttal. But let's talk about management responsibilities. Anthony and Leslie. Let's start with Anthony, if you don't mind. What is senior management doing to really demonstrate the cultural concerns beyond the typical memos? What specifically are you seeing them doing?
Okay, it's probably going to take more than 1 minute, but I think that it's really important to have things like conduct weeks, which I know that some French firms have organised, with multiple events, for example, events that are engaging on defining what people mean in terms of culture. A lot of firms will say, or senior management will say, your culture is putting clients first, following regulations. Fairly easy to understand, but can lead to some wrong outcomes if putting the client first means that you create other kinds of problems internally. More complex things are around purpose, fairness, fair outcomes for clients. And a lot of these conduct weeks will be sponsored by senior or middle management, meaning that they're engaged and involved and will be focusing on different elements of conduct. The other thing that firms are doing is having dilemma training, as it's often called, workshops that show that there are quite often no right answers to any particular situation, but they get people to think about those more complex issues like purpose, fairness in terms of outcomes for clients, so that they have, if not the right answer in any one situation, because this is never binary, they certainly have the right approach to dealing with a situation within the culture that the firm wants. A lot of those events that I've seen have been attended by the FCA to give their view, but also by psychologists, for example, to explain why people react in the way that they do. And I think the more support that senior management can give by hosting some fairly high-level events like that, or significant events like that, can only be useful.
Thank you. Leslie?
So I echo the part around these conduct weeks. We've done that in the past. I think now it's also the opportunity to move them into conduct agendas throughout the year. So rather than just 1 week, having them throughout the senior management involvement. And I would also just, for one more, to be quick and short and sweet, I would encourage senior managers and what I've seen in our organization doing reverse mentoring. So they become the mentee basically, and someone either junior from a different
Hi everyone, we've had a bit of an issue with some of the sound audio during that panel, so hopefully we will be able to return to that panel soon. We've certainly had some really excellent insights and discussions on conduct and culture. We know we've had some great questions. We probably won't get to all of those questions, but we might get an opportunity throughout the conference to explore some of those questions in greater detail. We've got a second session on culture after the break. And if you've enjoyed the first panel on conduct and culture, which I think was excellent, had some very good speakers, please do go and have a look at the virtual booth. There are 2 excellent reports from Capital Forensics there. There's also a really good video, so if you have the time, please go and do that. I think we may have to leave the panel there. It's an unfortunate glitch. These things happen. Thanks for bearing with us. We're now going to lead into a network break. In fact, it's not your usual network break. So perhaps before we do that, I'd like to say a huge thank you to Stephen and to the other panelists for what was a great discussion. And we will now move into that break. We're going to be joined by Alex Crowe, and this is a virtual mind reading session. It's been very kindly sponsored by Latham and Watkins, and this stream is particularly engaging, and I understand that you're going to need to open Zoom separately. So hopefully you will have had that in the joining instructions and you'll know what to do. So stay umbrella and open Zoom. Now on this page that you're all in now, look above me, there's a drop-down menu. Click on the mind reading session and Alex Crowe will be there waiting for you. Enjoy the session and we'll be back at 11:05 for our second session on conduct and culture. morning, everyone, and welcome back. Apologies for some of the technical glitches this morning. We hope that you've been able to take a break and that everything is now restored. We're going to continue our conduct and culture theme today in this next panel, Leading the Conduct Agenda. And we are delighted and truly honoured to be joined by Derval Rowland, Director General Financial Conduct, Central Bank of Ireland, by Tracy McDermott, Group Head, Corporate Affairs, Brand and Marketing, Conduct, Financial Crime and Compliance at Standard Chartered, by Catherine Brown, Partner at Oliver Wyman and member of the FIC Market Standard Board, and by Maurice Evelyn Bufton, who is CEO of Armstrong Wolf. They are incredibly experienced individuals. We're thrilled to have them on the panel. Details of their bios are available in Brella, so we won't go into great detail there. So let's start the session. I'd like to welcome everybody, and perhaps we'll start our conduct panel in a sort of setting the scene. And I know that Derval, perhaps you might like to start the conversation by giving us an overview of your thoughts and the priorities of the Central Bank of Ireland.
Thanks, Louise. And I first of all want to thank you and everybody for inviting me virtually to this panel. I have a bit of a cold, it's not COVID, and I hope my connection stands up to the task. We're all living in really challenging times. The threat of COVID continues to threaten our health systems, our economies, our loved ones, and our businesses. And we're all working in a near exclusive working from home environment that we never had anticipated just a short few months ago. And as we deal with this immediate context, we're also seeking a path forward. And of course, we need to be adaptable, risk focused, but we need to be brave enough to forge the pathway. I think all of us, regulators and firms alike, I hope we can agree that our central focus has got to be on having a well-established and integrated capital market that provides sustainable investment and sustainable economic growth. But progress on capital markets will mean little if it doesn't serve the best interests of our investors, our savers, our businesses and our households. So conduct matters a great deal, culture matters a great deal, and leadership matters in driving effective cultures in firms so that they can successfully meet the long-term agenda and the conduct risks ahead. So the COVID challenge is the context within which we're operating now. But firms have got to be resilient, be clear about prioritization. And that's where leadership comes in. It's not a soundbite. It really is about a serious commitment to the principles of integrity, honesty and reliability. In fact, all of these are the hallmarks of trustworthiness. So credible leaders need a vision for their business, which they have to communicate effectively to their people so that their people, in fact, will follow them. As a regulatory authority, we're committed to the European agenda, we're part of ESMA, we're committed to the global agenda, we're part of the IOSCO family. And for us, we have set our 5 principles for a proper and effectively regulated market. We need a high level of protection for investors and market participants. We need the features of products and the market price to be transparent. We need the markets and the firms operating in them to be well governed. And we need the markets to be trusted by those using the market to raise funds and those seeking to invest. Those markets have got to be resilient in times of stress and innovate appropriately. So we actually expect to see these principles embedded in every business, which means we expect to see them lived by the leaders and by the followers of those leaders. So we need to see those principles in market conduct strategies, governance frameworks, risk management, culture, values, incentives set for the teams and the people, in the measuring and monitoring, and in the reacting to things that go wrong, to reset. So it's all about people, and it's all about people's actions. And words are just the visible part of culture, the chunk of the iceberg above sea level. But actions and words of leaders directly influence what lies beneath the surface, the firm's unspoken rules, ideas and norms. And how alive are leaders really to the whole of the iceberg inside of their own organisations? What is visible and what lies underneath? So we need learning leaders who are open to moving the dial and bringing people with them, who build a culture that builds on a shared purpose, incorporating the standards of integrity, honesty and reliability that I referenced. Thanks, Louise.
Thank you, Derville. That's really helped set the tone for the session today and given us some great insight. I'd also now like to ask Tracy if I could turn to you and ask your thoughts on the current conduct risk agenda and some of your key areas and priorities.
Thank you very much. Thank you, Louise, and thanks for the invitation to be part of the panel today. Unsurprisingly, I would endorse pretty much everything Derville just said about the importance of conduct, the importance of the agenda and the importance of leadership. And I think it's really important to say that a lot of the future agenda is actually the agenda that we've all been working on for a number of years and continuing to really embed that focus on conduct as part of the way we think about our business and the risks in our business from a first line perspective all the way through to a third line perspective. If I take it a little bit more widely as to what are the key areas, key priorities at the moment, obviously there's been a whole series of new conduct potential risks created as a result of COVID. And if we think about those include the risks in relation to how customers are treated as we go into a difficult economic environment and the fallout for that and how firms manage that risk. It also includes the prolonged periods of remote working, which obviously Derville also touched on, and the FMSB has done some good work on thinking about how to manage those risks of remote working. I think, certainly speaking from a Standard Chartered perspective, we're pretty comfortable with how we've been able to manage through the sort of crisis phase. But as we go into a much more prolonged period and as working patterns change more generally, we all need to be thinking about what sorts of risks could that create. What sorts of subcultures or disconnects could that create if people are not within the office, and how do we manage those? We also need to be realistic about the economic concerns are not limited to our customers. Our own people may be worried about job security, either their own or members of their family, and that could encourage people to take shortcuts, either shortcuts which are deliberately breaches or shortcuts that people take because they want to outperform, they want to make their numbers, they want to show their productivity. So there's a whole bunch of COVID-related issues that are very high on our agenda to think about. Alongside that, we have non-COVID related priorities. COVID has accelerated digitisation, but it was an issue that we were grappling with before COVID and will continue to do so after COVID. How do we adapt conduct practices and conduct rules that were designed for a mainly analogue world to an always-on digital environment? And how do we think about conduct, not just in the sense of transparency to customers, but also things like the resilience of our systems and our ability to keep them operating 24/7, 365 days a year. That's a conduct issue, not just an IT issue, because it's a customer service and expectation issue. Also, the way we're working, again, this isn't exclusive to Standard Chartered, but all of the big financial institutions are working with new partners, working with fintechs, working with big techs, learning some of the really good stuff about their customer-focused ways of doing business. But we've got to make sure that in those new forms of partnership, we recognise also the duties and responsibilities we have to markets and to customers and to regulators. So that, again, is an evolution of where we've been. Data and increasing use of artificial intelligence, machine learning raises all sorts of ethical questions. What are the principles that each of us as individual firms want to apply, and what transparency are we giving to customers about that? It's also an area where there is an increased regulatory focus. We've already seen standards in Hong Kong and Singapore being imposed by the regulators. Bank of England has got a working group on it here. clearly an area to continue to focus. And then LIBOR transition, obviously something which we probably would have been talking about a lot more if it hadn't been for COVID this year, but still remains a key area to make sure that those are focus on the conduct aspects of that as we go forward. So I think in summary, plenty to keep us occupied, building on where we've been before, but with some new angles to it as well.
Tracy, thank you. That was certainly really insightful and valuable to us here. We'll certainly be looking at LIBOR and IBOR transition later on today. Both you and Derval touched on good leadership, and I just wanted to turn to Maurice and ask you your thoughts about senior leadership and how that can ensure or how that can influence the success of establishing healthy cultures within organisations.
Thanks so much, Louise. And certainly speaking to the other panelists, I'd like to thank you for the opportunity of speaking today and also to be sitting along such esteemed individuals. I'm going to really focus on the today because I think the pandemic has created a convergence of the imperative nature of leadership and indeed, I'd say empathetic leadership in that context. And it also is married to a need to think more creatively about meeting the conduct agenda as we're in a desiccated and distributed workforce. I think we're now accepting that we are business as abnormal for an unforeseeable period. And therefore, where we're looking for emerging risks on the conduct side, in fact, many of those risks have probably emerged, it's just they've already happened, but it's actually when they're going to emerge. Leadership is going to be imperative in the coming months, and it will shape, I believe, the leadership agenda for the future. In fact, leadership in crisis to me is leadership in its purest form. And I think that there has been some discussion where you'd almost like position leadership as being the nirvana, that the position, if we get to that position, then all will be well. In my view, it offers a map, perhaps, to this destination. I mean, it can certainly highly influence culture, but it must be married to individual and collective purpose, must recognize and account, for me, something called in a global business model, national identity and how cultures and conduct are different in each location. Embrace technologies, which has been guided, of course, by law and order and regulation. But within this framework is empowering leadership to have the freedom of movement and expression with per organization, which collectively will set the culture for the industry. The question is how. And to my view, yes, you have regulation about the impact of SMCR, which many would see the most effective and in many ways the most simple of regulations. And I've seen this over the last 5 or 6 years in close connectivity with the global COO and Chief Control Officer community. That's what my business serves. And I think looking from the lens of the COO, the Chief Control Officer, who the COO being the right-hand person to the principal leader, the CEO, it's very interesting where you see actually the application of leadership effectively de facto in the trenches in first line. And it is sharing the burden of leadership at all levels that I think is going to define culture. And that is leadership right down to the most individual level. Leadership, there's this cliche, of course, that leaders are born. No, they're not. You can create leaders, you can make leaders. But I think at this moment, if we take the human impact out of it, we take the economic impact out of it, I think COVID is actually throwing the industry an opportunity to accelerate itself in relation to addressing some of the conduct issues and accelerate itself in actually manifestly changing the culture. Any organization that says, look, well, how do we hold on to the culture from the past, I think is missing the point, because so many things are out of their hands in relation to the evolution of culture. And it is how you lead your business into a new culture. That is the test today of any leadership, and sharing that burden of leadership at all levels. And I think if you look at the beginning where there was that common purpose when the industry deployed and did extraordinarily well in deploying and making itself operationally effective very quickly, there was that initial period of actually the industry could be virtual ad infinitum. But I think what we're seeing now is we are trading off a half-life on the strength of culture. And I think in 6 months in that we are now in a point where we're looking at a sense of fatigue. And although we haven't grasped the actual benefit, the quantification of benefit of culture, we're starting to understand that there is intuitive benefit of actually having a cohesive culture, which is led from the top all the way to the bottom. My view is, though, actually, while you've got a desiccated and distributed workforce, what lessons can be learned that will help shape culture? At all levels, you need to train your individuals in leadership, and more importantly, probably in the present situation, in self-leadership. Give them the tools from time management to self-belief to managing downwards to peers and upwards. I think if you get that right and you invest in your people, you will actually give a clear intent and in relation to your level of importance at this moment is about your people. They are your business and they will shape the culture. So I think in many ways leadership can be overcomplicated, and I think at the moment we've given an opportunity to look at it in a most simplistic view and lead by example, of course, but lead at all levels. And I think if you do that, then you can shift the dial towards changing the culture of your organization, which ultimately the benefit will be helping to address the conduct agenda. That's what my views are, but particularly I'd say from looking from in the trenches, from the eyes of the COO, the right-hand person to the business.
Thank you, Maurice. Again, very, very insightful there. I'd like to now turn to Catherine. Now, Catherine, I know you've got some really interesting thoughts on the streetlight effect and the back to the future effect. Can you tell us a bit more about those concepts?
Absolutely, Louise. Thank you. And just to say also, I'm delighted to be here with you and with my esteemed fellow panelists. But yes, actually, there are three things that I wanted to mention. I wanted to talk about the streetlight effect, about the fact that culture is alive, and then also about the back to the future effect. So let me do that in turn. So first, the streetlight effect. So we have a lot of talk across the industry on tone from the top, and tone from the middle, and tone from within. And these are all incredibly important. But by perhaps at times over-focusing on the tone from the top and on what is said, we risk being a little bit like children looking for our keys in the dark under the streetlights. In that we're looking at the obvious. And when I speak to leaders across the industry, I ask them, what are you personally driving and changing? And that can be within your own firm. It could be through bodies like the FMSB or AFME, but what are you personally driving and changing when it comes to culture? The second point on culture, culture is alive and evolving. And I think, Maurice, you put it very nicely when you talked about how it's evolved and how things have changed over the past year. But the fact that it's evolving means that many of the linear approaches that leaders have tended to gravitate towards, whereby you measure, you design a solution, and then you implement, don't work. They don't work in terms of changing culture. So to be a good leader in this context, you have to be willing to experiment and to try out things that are different and new. And then finally, to talk about the back to the future effect. So back to the future, many of today's leaders didn't learn their trade in this environment. Certainly not the environment we have this year, but even more broadly, it could be that maybe diversity was seen as being about quotas, for example, rather than performance. It could be that if it was legal, then it was perceived as being also right. And it could be that it was in a time that was before social media. And before technology being as important as Tracy has rightly highlighted it being today. And that just means that I think as leaders, we have to ask, do we have the competency to lead and to judge today and in this environment? And to quote Herminia Ibarra, what we need is leaders who are learn-it-alls rather than know-it-alls in that context.
Catherine, thank you. Very interesting. And perhaps if I could turn to Tracy now for a sort of insight on board level and sort of ownership around leadership.
Thank you. So I'd start off by, first of all, saying I completely agree with both what Morrison and Catherine have said, that actually tone from the top is not in itself enough. It's to my mind, it's a necessary condition, but it's not a sufficient condition. And you do have to have that leadership at all levels, not just people at the senior levels saying the right thing. But having said it's not sufficient on its own. It is absolutely necessary, because ultimately the board, the executive, are the people who are setting the strategic direction of the organisation. And it's really important that not just in terms of what they say, but also in terms of what they do, that they are demonstrating how they live those principles of good conduct. And that is obviously about how they deal with particular issues, but it's also about the structures they put in place. It's about how you remunerate people. It's about how you talk about what's important to you as an organisation. It's about how you promote people. So you really do have to have that sort of senior level steer in order to support the leaders at all levels, as I think Maurice called them, in being able to also drive that agenda for themselves. And I think it's also picking up on the point Catherine just made around learning tools, and I think reflected also in Derval's opening comments, this constant need for leaders, again at all levels, but particularly at the senior levels, to be open to learning and to be open to listening to their people, because you can have a very idealized view of what's actually happening within your own organisation, or what it's like for people trying to operate on the front line, if you just take it from your 30,000 feet level. So that willingness and openness to ask questions, to really listen to the answers, and to act on those answers is, to my mind, a very critical part of the leadership journey in driving forward the conduct agenda.
Thank you, Tracy. And Derval, in your opening remarks, you set some expectations of what you expect firms to be doing. Do you have any additional insight here?
So I recognise that as a regulator, we could not possibly set an appropriate culture for any business. That absolutely is a matter for the leadership team to make sure they set and drive and embed that in their own business. But as a regulator, we think we have a legitimate role in demanding that aspects of a culture are present and infuse the whole of the organisation. I like to think of it as an ethical culture. The foundation stones that I talked about, integrity, honesty, reliability, the hallmarks of trustworthiness, need to infuse an organisation. And all of the other speakers are right in what they say. It needs to be connected through a network of leaders throughout an organisation that deliver for a business. And through their strategy, governance, individual accountability, decision-making structures, approaches to people management, incentives, it needs to infuse the people, their attitudes, and the systems of control. For us, what we've seen as a regulator, in some ways disappointing, that we have interviewed some really senior people who don't seem to know or understand, for example, their own conduct risks, their own conduct risk frameworks. That's prompted us to lead by setting the standard of expectation through Dear CEO letters, placing responsibility directly on them, because I don't think you can lead from the neck down. I think organisations have got to lead. I think Tracy was making this point, from the head right throughout the whole of the body. It's a corpus that moves together the whole of the organisation. And what we also noticed in an extensive piece of culture and conduct work that we did into our domestic banking sector in response to a huge mortgage scandal, but I think the insights travel. There was a lot of espoused ideology or vision for where the businesses thought they were or expected to go, but not an awful lot of actual implementation to back that up. So there was a definite gap between the espoused direction of travel and the actual direction of travel. So this is a practical science. It's a vocational skill, I think, leadership, and the organisation must have the clarity of the vision and the tools to implement, and then the checking to make sure it's being delivered on. But I think what we also see is that another dimension to effective leadership is diversity of thought, skill, and approach. And in that way, we think that a very rich, diverse, and inclusive group of people running your organization will make for better risk identification, better decision making, and we think would improve culture as well.
Thank you, Derval. And perhaps if I could broaden out that culture, diversity and inclusion topic and turn to Tracy. for some insight on where perhaps you've seen good examples in this space.
Thank you. And again, I at the risk of sounding as though we're all saying the same thing, I am going to echo what Derval said, which is, yeah, effective risk management is absolutely benefited by real, genuine diversity and inclusivity. So genuinely diverse views that will challenge the status quo and will ask the question of why we're doing things. And we'll do that against the hierarchy or without necessarily feeling the need to sort of defer to the hierarchy. And we've all heard the stories of, you know, planes having crashed because the co-pilot didn't want to upset the pilot and so on. You know, fortunately we don't have quite that same outcome if we get things wrong, but bad things can happen. And actually ensuring that you have diverse voices who will be challenging the status quo and saying, why do we do this, is really critical. And those diverse voices are only valuable if they're actually included in the conversation and we're actually hearing those voices. So I think that the sort of good practice examples are really one of the things we've been looking at has been the lessons that we can learn from the airline industry, where the whole concept of just culture, as it's so called, has been embedded over the past, you know, several decades, as a way of making sure that everybody feels it's their responsibility when something goes wrong to identify that, to share that, so that people can learn from mistakes that are made and ultimately make the system safer. And actually, when we look at that in a financial services context, that doesn't mean there's no individual accountability. Obviously, there may be individual accountability, but actually your starting point is to say, why did this go wrong? Is it a failure in the system? Is it a failure in the way we train people? Is it a failure of understanding of what the directions were that people were given? Or actually, is it just that somebody actually did something wrong? Because by encouraging that openness and that learning culture, you actually help to encourage people to raise questions and concerns when they have them. And we've been piloting this approach in a couple of areas, and we've seen some really positive outcomes, including much quicker escalation of operational risk events that happen because people genuinely feel that actually we want to learn and that we want to know about these things, rather than thinking, I better find the solution before I pick that up. So I think there's lots we can learn from other industries, and that's an area where we've really been focused.
Thank you, Tracy. And then perhaps, Maurice, if I could turn to you for some thoughts on diversity and inclusion here.
That's very interesting in relation to, and I applaud the industry for what it's done over the last 3 to 4 years in trying to address this, but we all appreciate that still much needs to be done. And when I look at, say, what my business does around supporting the COO, if you look at representation within the COO community, I think the industry has been quite good in relation to getting addressing or getting reasonably fair representation for female representation at the COO table. But one area that it has failed categorically is within representation of for ethnic minorities. And therefore, what you're missing is a key component part in relation to inclusivity of thought from actually embracing such communities. And again, if you then look from a leadership perspective, where the COO is the right-hand person to the head of the business, and all the arteries and the veins lead through the COO's office in one way or the other, they can be instrumental and influential in relation to setting the tone, setting the tempo of the business. And unless you have full representation and inclusivity within, say, the COOs or the business management community, then I think that could potentially impact the whole industry, the business as a whole. So whilst there's been some good effort within this space, there's still an awful lot to do. But I do think that one important thing, when I look for being objective, looking outside the industry, looking in, I do honestly believe there's the collective will at the top to make this happen. I don't think, and I also believe that tomorrow's generations, it's just part of their DNA as well. So the obligation of the present leadership is really to leave the industry in better order for the leaders of tomorrow. But I do think there's more work to be done to really make sure that we not just embrace the principle of inclusivity, we actually make sure that we hire people in, bring them in, retain them, and then take them through the promotional ladder. I obviously look from the center point from the COO's perspective, but I do see the benefit of the dialogue when we have COOs sitting around the table. It's a tangible difference when you actually have an enriched group of individuals from different backgrounds, different cultures, different nationalities around the table. And there's much to do, but I am relatively confident that we are on the right path. But what we now need to do is actually still do a lot more work to actually take this forward.
Thank you, Maurice. And just drawing on your point about benefits, I'd like to now turn to Derville and sort of ask that same question to you, linked to sort of benefits and representation on boards.
So you won't be surprised to hear me say, as a regulator, we're evidence-based and evidence-led. And I particularly think the lesson from groupthink was acutely felt in our jurisdiction in the aftermath of the financial crisis. But I think it's trite now to say that we all understand the benefits of diversity, and there's a growing body of literature that demonstrates empirically that diversity in, of course, it's not just about gender, and I'm very fond of the Christine Lagarde quote saying that if Lehman Sisters rather than Lehman Brothers had been the situation, things might look quite different. And I am a subscriber to that thinking, but I recognize it's about diversity of socioeconomic background, it's about diversity of thought, it's about diversity of training skills, it's about ethnic diversity. It's about strengthening perspectives so that your decision making is more considered and therefore more robust. So we see that body of evidence that can demonstrate that financially leading firms have a more diverse composition at board level, and that certainly there's evidence to demonstrate that women's representation on boards can decrease the probability of fraud. So it's a bottom line issue as well as everything else. And because we need to contribute to the debate in an evidence-based way, we've been publishing our figures in terms of applicants for senior roles in the financial services industry in Ireland in fitness and probity. And we've added to that to publishing our own analysis of the composition of boards and management teams in the largest banks, insurers and asset management firms. And what we see is that men hold 87% of the senior positions in large asset management firms, 80% in large banks, 74% in the large insurers. There's a pronounced gender imbalance at board level, and especially in revenue generating roles. So men hold 85% of revenue generating roles. Now, things are changing, but extremely slowly. We see that female applications for board level positions have increased by 4 percentage points from 20% in 2018 to 24% in 2019. So for us, given the importance of diversity and inclusion in the culture and the resilience of financial services firms, it's an area that we're going to continue to focus on, continue to spotlight, because that research suggests that companies in the top quartile for gender or racial and ethnic diversity are more likely to have financial returns than the national industry medians. And we think they're in a better position to be effective leaders in their industry.
Thank you, Derville. Some excellent comments there. And on the diversity and inclusion theme, I'm thinking to the work of the FMSB. I know there's great things happening there. Catherine, could I turn to you on this?
Yes, and let me make 2 points on this. I mean, one kind of picking up the thread that Derville's just been discussing. It's 2020, right? And this is about performance. And so we need to be more systematic. And we see real change happening across the industry for things like climate risk, right? Where banks are going through the process now of looking at the world and at their operations through a very different lens, and thinking about every aspect of their business. And what I would like to see, what I think would be more effective, is if we can bring the same level of rigor to social risks and to diversity and inclusion as we are to topics like climate, where we're beginning. I think that would be powerful. And on the topic of power, my second point is find your power. So I was involved with the 30% Club earlier this year in clarifying their theory of change. And what we did as part of that was think about the mission statement: at least 30% women of all types on boards, and think about what that means for a specific market. So what are the supply side drivers? What are the demand side drivers? And who needs to change? What needs to change if we want to move the dial? And I think that the 30% Club's investor groups are a great example of that in practice and how it's worked well, where you have collective voice asking quite challenging questions, and that is leading to real change. And so in that context, what I want to kind of put to people, what I want to ask is what's your power, and how is your organization using its power? And this doesn't need to be rocket science. This can be simple things like, who's your safe pair of hands? Who is your go-to as an individual within a compliance function when you need something done? And as a bank, who do you finance? I think there are a series of good questions that we can ask about where our power is and how we use it to drive change.
Thank you, Catherine. That's certainly very helpful and very clear. So really great comments there. So we focused a lot on where we are now and the current landscape. And I'm conscious that we've used up a lot of time already on this really great discussion. But perhaps if we could shift the focus to the future, and if we would sort of think about some of the emerging risks and how firms and regulators might respond or react to them. And on this question, I think I'll go to Tracy first on sort of identifying and managing some of these emerging areas.
So I'll try and be brief because I know we're up against it in terms of time. But just to link back to the last inclusion question, I won't repeat the risks I talked about at the beginning of the things that we see as key areas on the horizon. But if I take a step back and say, how can we most effectively as an industry manage and identify the risks that are coming, I think it is all about how do you take that broad perspective. So how do you think about your business through the lens of the bigger picture, whether that be the environmental bigger picture, whether it be changing customer expectations in terms of speed of delivery and always on, whether it be geopolitical tensions, which are obviously running rife, or whether it be the changing demographics. So my big kind of takeaway to make it brief is, let's not look at conduct risks through a set of very narrow lenses about what the regulators want or disclosure to customers. Let's look at that big picture in which we're all operating and think about that, how that will impact the behaviour of our own teams and the behaviour of our customers and the behaviour of the wider market. And then we will get much better at being able to see round corners and to prevent things going wrong in the first place rather than picking up the pieces afterwards.
Thank you, Tracy. And then Maurice, I think you had some thoughts here on future risks and management of them.
Yeah, so I was just picking up some of the points that Tracy was making, particularly around geopolitical risk. If you look at the industry has spent so much time, understandably, looking over its shoulder at the past and looking to ensure that the past will not be will happen again. And whereas, how do we pivot the attention of the executive to look forward? And rather than looking at it's more around what I would term as, say, threat management. How do you define what a threat, an institutional threat is to an organization's ability to operate? And if you look from a geopolitical situation, we have at the moment, we have one live, which is the Hong Kong-China dynamic, and you wrap into that the interface with the US. We then have the US presidential election just sitting on the horizon. And then hot on its heels, we have Brexit. Now, all of those actually have significant impact in different ways, or potentially on the financial services industry on a technical basis. But actually, then it's actually under asking the question more so what? So what could this actually mean for me? As Tracy said, sort of how could a geopolitical event potentially impact or shape behaviours which are framed in society but are then taken into a bank and into the industry. And I think what we need to do is actually pivot more to more investment in constructive horizon scanning and emerging risk scanning, looking at the aggregated data you have around non-financial risk, collecting it so you can actually have an informed discussion about the so what. And I think the most important thing in that is not to have a failure of the imagination. I think what we need to do is free up the industry and free up the leadership to ask that question, so what, to anticipate it and be unburdened by a framework of thought. But as I said, I think effective horizon scanning is going to be based upon intellectual freedom and ensuring that any future challenge can be met where at all possible by not having a failure of the imagination.
Thank you, Maurice. And looking at the time, I think looking at the programme, we can actually squeeze an extra 5 minutes into the discussion so that we can sort of extend a bit of the discussion here. Catherine, thoughts from you on the future state?
Yes, absolutely. And maybe to start by saying that I led an exercise to scan the horizon for emerging risks and emerging vulnerabilities for the FMSB at the end of last year, which was a very dynamic exercise and brought together a broad group of people with quite diverse perspectives, linking back to what we were discussing previously. So it was banks and asset managers and market infrastructure and corporates and more, people with very different vantage points. And this provided a very rich view of what was on the collective conscious and what could go wrong. So I think one thing to just proactively engage, be dynamic in thinking about what these risks are, but also look beyond your own sphere, beyond your immediate institution, for people who really have a different point of view. The types of issues we came up with, I think it was things like sell-side participation choices, social and political risk, tech reliance, data as a currency, greenwashing, and the list goes on and on. But another point to make, I think that as an industry, we need to have more than just an admiration for the problems. And I'd like to introduce the concept of running with scissors, because I think that firms found themselves quite understandably unprepared for pandemic disruption. But having been a part of many discussions with risk and at conferences over the past, or over the year preceding this one actually, pandemic was a risk that was on the radar for many global banks. We had thought about it as an industry. So I think that as an industry, we need to be a little bit better about playing out scenarios and doing a little bit of wargaming, and that's because if it's going to feel as if it feels like we're running with scissors, then we want to have a clearer view of the road ahead and how we might navigate it.
Sorry, I think you might have lost my audio there. I'll say that again.
Can you hear me, Louise?
I can hear you. Perhaps I could turn to you about solving some of the new challenges.
So I think Tracy identified a lot of the risks earlier that businesses are facing. Maurice and Catherine gave excellent advice about running with scissors and being future focused and not constrained in being imaginative. For me, lenders need to be risk aware, risk responsive, but they have to remain centrally focused on a long-term vision that's infused by an ethical culture that will serve them and all of the people who work for them into the medium and the long term. For me, that really essentially is about, in the end of the day, of course, as a regulator, you won't be surprised for me to hear you need a strategy, you need systems to ensure that that's delivered, you need metrics to measure, to monitor it, you need an approach to deal with risk events and to respond accordingly. But all of this will work best if you prioritize your people over your procedures to solve your new challenges ahead, because procedure and process will not solve your new problems. The fantastic workforce that you have, harnessing their ethical muscle and their intellectual capability is what will drive your business forward into the new future. And then you'll be able to deal with greenwashing, the challenges of the new sustainable agenda, the change in digitalization and how we have to harness ethical programming and systems of control in a world of greater automation and remote selling. How we'll respond to COVID in terms of a workforce that now doesn't see each other on a daily basis, the undoubtable benefits that some feel and the burdens that others feel, and how we actually have to be very people focused, harnessing the great benefit that every business has, which is the intellectual and ethical capital that all of our people bring. Thanks, Louise.
Thank you, Derval. And I think that concludes the sort of key running order of our session today, the sort of panel discussion. We have had some Q&A come in from the audience and picking up on some of the themes that we've been discussing here. One of the questions is focused on the UK regulator, the FCA, and the question is, the UK regulator has spoken out about firms' gender diversity issues, but it's not been vocal about race recently. Is there a reticence? And then there's a sort of follow-up question or a related question as to what other criteria beyond gender diversity and inclusion could have an impact. So I don't know if we have on the panel who wants to pick up the question there.
I could make a point on this. We've just set up something called the COO Scholarship Scheme, which is focused on creating career opportunities for ethnic minorities globally. And when we've set it up in Canada, we've set up in Toronto, New York, and London. And it's interesting when you talk about the question of why race hasn't been brought up. Because we came across that in actually just the naming of the scholarship scheme itself. So, for example, in the US, we've actually defined it as the Black Heritage COO Scholarship Scheme. We courted the opinion of 40 COOs in relation to how we should name it. Now, actually, it's interesting. I looked at that specifically from a UK lens, and I saw that as actually, well, you're exacerbating the problem of you're excluding certain components of parts of race by defining it as Black heritage. And if you then took that name into the UK rather than BAME, for example, how would that be digested from a UK perspective? But out of the 40 COOs, 37 of them supported the definitive and narrow naming of the scholarship scheme under Black heritage. When we did it with the 40 comparative COOs in the UK, only 7 did, because they said it had to be had to be inclusive. And I think that's one of the challenges that we have it is a worldwide problem, it's a common problem, but there are regional nuances and sensitivities how you address that. And also you have, for example, in Canada, you then actually put in the indigenous population. So I think that it's a complex problem to get right and set the tone right. I think there is certainly from the Black Lives Matter, it has raised this as an issue, and quite rightly so. But there are different underlying drivers and also influences and histories in the UK to the US, which means probably why race itself hasn't been so preeminent in the narrative in the UK as it is in the US.
Thank you, Maurice. Perhaps if we could finish with perhaps a sort of 60 seconds from Tracy, because I know you've been doing some thinking on this topic.
Yeah, thank you. So 2 things I would say. One is, I think as with every other organisation, we've probably been doing quite a lot of soul searching in the wake of the Black Lives Matter protests this summer. One of the things we have been doing is listening sessions, talking to our colleagues. And I very proud to work for an organisation which is incredibly diverse, but actually listening to the experiences of our colleagues, both within and outside the bank, really brought home to us from a senior leadership perspective, actually how little understanding we do of how other people's lived experiences. These conversations are really difficult to have, and one of the things we have done is published a toolkit, which we've actually made available publicly, about how to talk about race. Because we recognise that lots of us shy away from having some of these difficult conversations because we don't want to say the wrong thing, which means we say nothing, and then that actually doesn't help move things forward. So I think there's a really important thing that's happened this year because of the protests and because of the tragic events that triggered those, which has actually really brought this conversation much more out into the open and said, let's actually try and understand and talk about it. Just to follow on to the second point, which was in the initial questions, which are what are the other things that matter? I mean, obviously diversity has a massive range of different facets. Some of the ones that I think are particularly interesting and challenging for us in financial services, social mobility, Derval touched on that earlier. You know, we need to get people coming into our industry and wanting to come into our industry from a range of backgrounds. Age, we tend to be either very junior or very old in our industry, and we lose a lot of people in the middle of both genders. And actually, is that right? How do we manage that? And obviously disabilities, both obvious physical disabilities and also hidden disabilities. And I think the whole wellbeing agenda is really focused on that during COVID. So I think there's a whole range of things we need to be thinking about, but at the core of all of them is being willing to listen, to have that conversation, and to help people have some of those more challenging conversations we might otherwise shy away from.
Thank you, Tracy, and it really is a critical topic. I'd like to thank you all now. I realise I've taken us over time. That was a phenomenal discussion. Thank you to the audience for your Q&A. Derval, Tracy, Catherine, Morris, thank you very much for joining us today. We're thrilled to have you on board, and we'll now go towards a brief break. Good afternoon, everyone. Welcome back. I'd now like to introduce the next session of the day. It's certainly very relevant. It's the Market Abuse Regulation Under Review, which will be moderated by Nick Bailey, Managing Director of Compliance and Regulatory Consulting at Duff & Phelps. And I think without further ado, we'll go straight into the session. Nick, over to you to introduce your panel.
Thank you very much, Louise. Good afternoon, everybody, and welcome to this session on the Market Abuse Regulation Under Review. Thank you very much to AFME for giving me the opportunity to moderate this panel. It's a topic that's close to my heart. Before I joined Duff & Phelps, I was with the FCA, where I was the Senior Markets Advisor, and I helped to run the MiFID II and MAR policy projects. And prior to that, I was Head of Regulation at the London Stock Exchange for nearly a decade. So MAR is very much something that I continue to stay personally involved with in all the work we do with our clients. We've got a great panel here for you. Let me introduce them to you. Anne Mannering is a lawyer in the London office of Latham & Watkins. She specialises in financial services regulatory advice, has experience in advising a wide range of financial institutions on legal and regulatory risk management matters, with particular expertise in relation to European regulatory developments, including MAR, and sits on a number of the AFME working groups, including the MAR Review Working Group. Welcome, Anne. Emily Balasat is a qualified solicitor and head of regulatory change for compliance in BNP Paribas Corporate Investment Banking Division in the UK. She previously worked in HSBC's Global Banking and Markets Division and at Linklaters in both compliance and legal roles. She's implemented a wide range of projects for compliance, including the market abuse regulation. Welcome, Emily. And lastly, but not leastly, Rodrigo Buenaventura, excuse the pronunciation, has been the Director General for Markets at CNMV, the Spanish regulator, since March 2017. From 2011 to 2017, Rodrigo was Head of Markets at ESMA, where he participated actively in the setup of the agency and the regulatory work arising from MiFID II, EMIR, MAR and CSDR, among others. Before joining the regulatory community in 2005, Rodrigo had a career in the private sector as a consultant on financial markets matters. That's your panel, ladies and gentlemen. It's an excellent one. So I suppose before we kick off with the discussion, here we are 4 years on from the implementation of MAR, which for some jurisdictions was a massive seismic change. For other jurisdictions, perhaps including the UK, perhaps less so. It's fair to say also that I think in the immediate aftermath of MAR implementation, it got somewhat overshadowed by MiFID II as a colossal piece of legislation that kind of pushed MAR to the sidelines. But I think it's very timely now that we talk about MAR, and particularly that we focus on the review. We're lucky. The timing of the panel is great because just 2 weeks ago we got the ESMA's final report to the Commission on the MAR review. So we've all had a chance to digest that. 250 pages of pretty dense stuff, and we're going to move on to talk about some of that later. And we'll talk about the implications of what's in there and what's not in there. But it's worth saying also, over this summer we've also seen some extraordinary market abuse outcomes. It won't have passed people by that JP Morgan has been fined nearly $1 billion for market abuse in the US, as has Scotiabank, both for layering and spoofing market abuse offences, huge fines. There's been enforcement action in the UK and the EU, but it is dwarfed by what's been going on in the US as well. And so perhaps before we dive into the MAR review, perhaps we should reflect on whether MAR 4 years on has really achieved its purpose. And maybe pull up the first polling question, could we please, Andy? That would be great. So here's the question that I'd like us to consider. Do we think that EU MAR has been successful in combating market abuse in the European Union, in the UK? So for all of the delegates out there, please give us your view in relation to that. While you're answering that question, I'll probably read from the recitals of MAR. This is recital 4. There is a need to establish a more uniform and stronger framework in order to preserve market integrity, to avoid potential regulatory arbitrage, to ensure accountability in the event of attempted manipulation, and to provide more legal certainty and less regulatory complexity, interesting, for market participants. So that was one of the objectives of MAR, less regulatory complexity. Is that what we've got? Maybe we can just have a look at those results then, see what people think about whether MAR's achieving its purpose. 42% say, 40% say it's been quite successful. 24% say not particularly successful, very successful 20%, not at all successful, but that's good. So most people think it's reasonably successful, but it tends to be towards the middle. It's only 20% of people think that it's been very successful in relation. I don't know, any of our panelists want to come in relation to their reaction there? Are they surprised that we haven't got anybody who thinks it's been very successful? Anybody want to come in? No obligation to.
I guess it depends how you define success, really, and it's probably quite early on, 4 years on, because enforcement cases take quite a while to come through, so probably quite hard to determine at this stage, I would say. And I think there are areas that could probably be clarified in the regulation itself as ESMA picks up, and which we'll come to later.
Yeah. Okay. Thanks, Emily. Okay. Well, I'm sure we can reflect on that later if we have time as well. Staying at a reasonably high level, because we'll get to the detail of what's in the report later, but staying at a really high, one of the changes that MAR brought in, which I think was a significant one for everybody, was the sheer scope of the regulation. So we've got a universe now where MAR affects or covers literally millions of instruments because it uses the MiFID scope of admission to trading in the EU. And I suppose there is some extraterritoriality that kind of flows from that. So initially, perhaps to Anne, is there a fundamental problem here with MAR's scope in that it's so big and the things that flow from that in terms of what you've experienced in your work?
Thanks, Nick. Yes, certainly from my perspective, this is the number one issue that comes up consistently in practice because MAR has the instrument rather than entity-based scope, and because, as you say, it picks up these involuntary listings as well. It means in practice that what we see is actually quite a large extraterritorial reach. And what I really see that playing out as is that quite often you might have a transaction which on the face of it doesn't appear to have an obvious EU nexus. So it might be that, all the parties are in the US, issuer is in the US, the primary listing is there, but actually when you check you might find that the relevant instrument actually is tradable on an MTF in Europe. And therefore you are actually technically being brought into scope. And as you say, I think it is this involuntary listings, particularly trading on MTFs, that really does, as you say, expand out the scope. And I think that is important because it plays out, and this will be something we discuss throughout this session, I think, but it really affects the whole application of MAR. Market soundings is one I see particularly impacted by that, where quite often the obligations will be kicking in a situation which doesn't necessarily look like an EU transaction.
Yeah, it's that. I mean, unforeseen. I think extraterritoriality as regards offences is probably right. You don't want people sitting on a beach in the Caribbean and out of reach of MAR, do you? Abusing European markets. But there's a question about whether Apple is really an EU stock. Would if it's just admitted to trading on one of the little MTFs, it doesn't really trade at all in Europe. So it's a really good scope question. And interesting, not something I don't think that ESMA's really thought about in the review. I think we're stuck with the current scope from the sound of it. That's my impression anyway. I don't know if anybody else is coming in here, that this is not something, I know, Rodrigo, whether this is something that's ever really been considered.
Well, it's been considered, I think, mainly not from a MAR perspective, but from a MAR/MiFID perspective, which as somebody said, they go hand in hand. And definitely, I think the European regulation needs to be rethought when it comes to, let's say, things like Apple or Australian mining companies listed in Hamburg, for instance, that hardly trade ever. And I think that is relevant. But we need to take a look at this both from the perspective of MiFID, trading obligation and the like, and MAR, because doing that only in one of the two instruments probably would not reach the result.
Yeah, clearly it doesn't make sense. It doesn't make sense for there to be a complete mismatch there. So putting aside the scope of MAR in terms of the instruments it admits, Emily, what other aspects do you see of MAR that are particularly burdensome for firms? Staying at that fairly high level still. What else are they struggling with?
So I think market soundings firms have found quite burdensome, as have some of the recipient parties in terms of record keeping and the obligation to keep a log of all conversations or communications between parties, and the two-stage process that was implemented in MAR. So we've definitely had feedback from the business on that. Insider lists, again, I think the fields that need to be kept are quite extensive. There were personal data questions, and the question as to how you coordinate those lists between different parties involved in the transaction. Investment recommendations is also another topic that is definitely high up there. Again, because of the extensive range of disclosures and information that need to be given to a recipient, sometimes for ideas or sales notes that are a couple of sentences long. I'd also say extraterritoriality, just to add to what Anne has said before. I think that comes up in the investment recommendations space as well. And probably lastly, the surveillance obligations are pretty broad, and we completely understand it's the priority, but I guess it's separating out and finding a way of trying to work out how you determine market abuse or manipulation from a large range of data that firms are receiving all the time.
Just on that investment recommendations point, tell us a little bit more about that. So what are you saying? You're saying that the investment recommendations definition is just too broad in terms of what it captures, or what you said was that actually there's a lot of disclosure that's required in relation to investment recommendations. I mean, it's boilerplate though, isn't it? Isn't it sort of standard stuff that goes on all of these investment recommendations, about conflicts of interest and all that kind of stuff? Is that a huge problem?
Some of it is boilerplate static type data, but some of the fields are dynamic. So they require information from the salesperson or trading data. So that's one of the complexities around that. So it's not something you can simply prepare and roll out across the board. And obviously we've grappled with this for 4 years, so we've had to manage and deal with it. But I think if you go to any investment firm and ask them what they would change, that would probably be the top of the list, because it's quite burdensome in practice. And I think there's a question whether investors are really reading the data and managing it. Could it be better dealt with under MiFID conflicts of interest requirements, which seem a better place for it?
Yeah. Okay, interesting. So surveillance you mentioned as well. I don't know if anybody else wants to come in on this, on surveillance in particular. You've touched on there. I've heard grumbles about order level surveillance being very difficult, for example. That's something that MAR makes absolutely obligatory across all activity. Is that the sort of thing we're talking about, or are there other problems in relation to surveillance that you think MAR causes, that the scope is too difficult, it's too costly, it's not justified? Rodrigo, do you want to come in on that? Sorry, Emily, go on. Yeah.
Oh,
Emily,
sorry, I was going to say, orders is a significant expansion, or was a significant expansion when it came in. So yeah, but also it's the sheer volume, I think.
Okay. I mean, Rodrigo, you obviously do surveillance as a regulator. You expect your firms to do surveillance. As somebody with a slightly different perspective, perhaps from Anne and Emily, do you think Mars made a real difference? Because obviously we're talking about cost benefits here. I went looking for the original Mar cost benefits before, so I couldn't find it, okay, to see whether there are actually any real numbers for this. It feels like market abuse is pretty important, so most of us would say it's reasonable for the industry to bear a cost in relation to something as important as market abuse. But have you found that it's made a real difference in relation, that Mar itself has made a real difference in terms of your ability to investigate and prosecute market abuse?
Well, I would say the main objective of MAR was to harmonize a regime that was quite fragmented. And I guess that it depends on which regulator you ask, the type of answer that you will get. For instance, in the case of Spain, the kind of tools we had before MAR and after MAR did not change that much. We were lucky enough to have client ID in the transaction reporting under MiFID. Of course, transaction reporting, as you know, is regulated under MiFID, but is used mainly for MAR purposes. So client ID was here, so we didn't see a big change in that. But we saw, for instance, a big change with all the transaction reporting, exchange through ESMA, coming from other supervisors that did not have client ID before, and now the kind of picture you see, the kind of analysis you can do for prosecuting, but for detecting market abuse, is much more powerful, of course, and that was a positive thing. In terms of sanctions, for instance, there were some countries, again, it was not the case with Spain, but some countries with very low sanctions for certain conducts. Literally, in some countries, you had a sanction of maximum amount of 400 euros, and in other countries, for the same violation, you could go to jail, which was completely ridiculous. So one of the big virtues of MAR is it has reduced the incentives to do or commit the violations in this or that the jurisdiction because of a, let's say, enforcement arbitrage or sanctioning arbitrage. That was another big plus. And in terms of tools for supervisors, and probably answering to some of the concerns that were expressed by Emily before, I can understand the feeling of part of the industry of not knowing what happens with the report they do, the suspicious transaction reports they send, the surveillance. Now, what I can assure you is that they are tremendously useful for detecting and enforcing market abuse. For instance, on the suspicious transactions and order reports, the STORs, they have gone up. They have gone up in quality. They have gone up in quantity also. And we are receiving really, really useful tips of suspicious, conduct going on. So when you have, if you have at some point that sign of alienation that you don't know what your work is worth for, or where does it end, trust us, there is a real value. And for instance, we at CNMV, we send a yearly letter to the CEO of each investment firm, giving them feedback about the quality of that reporting, because we understand that sometimes you might have a feeling that all that information is lost somewhere. It's not lost; it's used, and we have, thanks to that, sanctioned more than 30 people in the last 4 years for insider trading, for a total of more than 3 million euros. Has nothing to do with the billion figures in the US. That would be something really exotic for a continental country in Europe. But and with spoofing and layering, that is also being very, very useful. The type of transactions that reports that we see, and we have managed to sanction up to 15 people for market manipulation, mainly spoofing and similar conducts, for more than 6 million euros in the last 3-4 years. So it has made a difference in that sense.
Yeah, good. Well, I'm really pleased to hear that, because I think everybody in the industry wants to hear that it's making a difference. I mean, at one end we see the enforcement outcomes, and as you say, there's a long delay. I mean, in the UK, the FCA has only had one outcome under MAR, which came out at the Abatista case. £100,000 fine for layering the other week. First one, 4 years on. It takes a long time to get this stuff out the door. So transparency about the value of this is I think really helpful to the industry. Otherwise, it just looks like cost, doesn't it? It just looks like pain and so on. I don't know whether Anne or Emily, you've had any experience of how much your clients get contacted, or how much your firm, Emily, gets contacted by regulators in relation to asking for insider lists, asking for access to this material that you're keeping very diligently, I'm sure, as to whether it's something that happens a lot, or whether largely it's being kept and put on a shelf somewhere.
Yeah, I'm not sure in practice about insider lists, how frequently we get contacted. I guess on suspicious transaction and order reports, I think I could echo what Rodrigo said. I think definitely from a UK perspective, we've seen more follow up on quality and volume of reporting, and I think the feedback is helpful. So yeah, that encourages reporting generally.
Okay.
And flagging items where you're not clear or not sure. I think that could always help, because on the regulator side, they can build a picture, can't they? If there's more than one store submitted.
Yeah, absolutely. Well, the value of stores has always been something that the FCA's talked about. Anne, did you want to come in there?
I was just going to add as well, there is the extraterritorial element. I think it plays out in a lot of areas, and sometimes we see people struggling with, if you've got people booking into you, for example, how does that play out into your surveillance obligations and things like that? And if that's a different regime as well, that can be difficult for the firm, because they might be relying on the third country entity to provide the information needed. So just some sort of additional interplays that can come up for firms.
Yeah, interesting. Well, hopefully we'll get time to talk about third countries and what's going to happen to the UK and whether it's a good idea to have diverging regimes or not. We'll come back to that. Let's get into the MAR review. 250 page, pretty dense. FX was the big ticket item, I think. This was the thing that we all sort of held our breath slightly and said they're not really going to try and use MAR to regulate the FX market, are they? That's and fortunately, which would have been a huge change. And I think ESMA has said, well, not yet. They're happy to let sort of self-regulation in the form of the FX code act as the sort of guardrails for now. And so I think that's putting that to one side. Emily, let's start with you. Did you think there were any particular surprises in the ESMA report? And was there anything that you were slightly disappointed not to see in there?
I think market soundings. There were a few items that were potentially surprising in that space. Around the view that Article 11, so reliance on the Article 11 market soundings processes, is mandatory, which I think is quite difficult in some areas when we talk about extraterritoriality, which I'm sure Anne will come on to. Also, it takes quite a broad view in terms of the scope of what is covered by the market sounding regime. So a suggestion that Euro private placement, blocks, M&A trades all within scope, and a real emphasis still on record keeping. I guess maybe I'm not surprised because it wasn't in the original mandate, but I think as an industry we'll have a slight disappointment that investment recommendations doesn't feature in it. I think in other areas I'd say it was broadly helpful, maybe other than pre-hedging and front running, where clearly, I think ESMA and NCOs want to do more work in that space around differentiating front running and pre-hedging, and understanding where pre-hedging could be beneficial. But I think there's a suggestion of client disclosures, transparency, and only being able to pre-hedge where you're taking on a principal position. I guess then there may be questions in practice as to how to effectively and efficiently do this. I know it's an area that was much debated under the FX code, and very much depends on the liquidity of the market and the particular transaction, and I guess investor or client that you're dealing with, how you manage these items. I think it's a very complicated space. So yeah, certainly we need to be involved in more debate in this area, but also be able to facilitate risk management for clients where they want it and are clear about the benefits of it.
It's quite interesting, isn't it? ESMA has they've gone into pre-hedging in quite a bit of detail, and they've planted some flags, haven't they, and said it's almost like pre-guidance guidance. It's not guidance because, of course, this has no force at the moment. All it is advice to the Commission at this point. It won't become anything for another year at least, I would guess, before it's got any kind of status, whether it's as guidance or even as law at some point. But it's quite interesting. Do you think it'll spook people a little bit to see ESMA saying, we think you should do this in relation to this, you should disclose, you should pass on the benefits, you should, and the various other things that are in there? It's really interesting, isn't it, the pre-hedging bit? Whether it will slightly spook people, because it very much flags the direction of ESMA's thinking and its direction of travel in relation to pre-hedging. And if it does spook the market, is that a good thing or is it a bad thing? Anne, did you want to come in on pre-hedging?
Yeah, pre-hedging, I'd absolutely echo what Emily has said. It was one of the key takeaways for me, these factors that they have laid down, particularly in relation to case-by-case disclosure. In my experience, that's really not market practice at the moment. That would be very disruptive. I think there's a couple of points where ESMA have done this. They have sort of laid their mark in the sand, but really it's at the point where it has to go to the Commission as a takeaway. So certainly my view anyway is that whilst this is an indication of the direction of travel, which is not necessarily in line with both market practice and certainly a lot of the lobbying that I have seen, it's not something that will kick in immediately, but it certainly will be a worry, especially, as I say, when they're moving to much more granular disclosure. That will certainly be a concern for people.
Yeah, absolutely. Okay. While we're with you, Anne, is there anything that you thought, anything else that you thought was a surprise, or anything that you were disappointed to go in there that you highlight? I mean, Emily gave us a fairly good list of things there. Do you want to pick up on any of those, or were there any others that you particularly had your eye on in relation to what you saw?
Yeah, so for me, again, it's echoing what Emily said, the two big takeaways. So it was pre-hedging, and the other one for me was market soundings. Echo the points that Emily has made, and really sort of the point that I immediately looked for when I opened the document was to see whether ESMA had maintained their position on Article 11 of MAR being mandatory, which they have done. And again, ESMA itself acknowledges there was an awful lot of lobbying on this point, because most of their responses reflected that this, again, isn't how market practice has interpreted Article 11. And also, again, expressly called out by ESMA that also a lot of people flagged that having a mandatory market sounding regime is very burdensome and disproportionate. Again, it feeds into these points we've already discussed around, firstly, because it applies extraterritorially, there's a very wide application to these requirements. And then because they are very sort of procedural and administrative driven, again, it's just adding to that burden. And at the moment, the sort of market interpretation does allow a bit of flexibility, because if you do have a transaction which doesn't really have much of an EU nexus, but MAR nevertheless applies, at the moment you might be able to take a pragmatic view that you are complying with local law and requirements, and therefore you have satisfied your obligations without walking through the detailed market soundings procedures. But the other thing that ESMA has again recommended is specific sanctions for failure to comply with Article 11. So, my concern really is there that removes any flexibility that we might have at the moment.
Yeah, I mean, the idea of it as a safe harbour, which is certainly what I think most people had thought of it as. Perhaps I was a little surprised to see it become something that ESMA clearly wants to enforce, and I know it's been adopted widely. Okay, everybody's doing it, and most people are doing it properly, I think, but nevertheless giving it force. Rodrigo, any thoughts on market soundings and whether the regime is working, and whether ESMA's going in the right direction with it, do you think?
Well, it wouldn't be appropriate to disagree. For two reasons. I cannot. I shouldn't deviate from the line of my authority. But I personally agree with what ESMA has done. It was very controversial until the end, whether to make that or to recommend the Commission to make that an obligation to fulfill when disclosing inside information, or when conducting a market sounding, or not. And I think the right choice is to generalize it as a practice that is compulsory in these situations, because, as you said, Nick, it has become common practice, and it is true that it has some potential links with extraterritoriality in some trades. Agree with Anne, but we need to deal with that probably specifically on the whole issue of extraterritoriality. We should not lower the standards on the market sounding because of the extraterritorial risk, which I agree it exists. No? But with respect to the usefulness of that, we have currently investigations on potential insider trading, happening through a market sounding, and when investigating those cases, the audit trail, the track record, the log that Emily or Anne were commenting, they are tremendously useful and they are essential actually for the investigation. So I acknowledge that it's something that you do always, and you might need it once out of 50 cases. It's true, but when you need it, it really makes a difference on detecting the guy that did the wrong thing and did insider trading with that information.
Okay, good to hear that. It's good to hear that. It's good feedback. And I suppose staying with you, Rodrigo, from an issuer's perspective, I'm thinking here of things like insider lists. I know that there's been some attempt to kind of get insider lists working, so they're talking about people who only have actual access to inside information rather than everybody that could have access to inside information, for example, is an obvious change to try and perhaps lighten the burden a little bit on issuers and the people who are working with them and so on. How do you think from an issuer's perspective this is going to, does it go far enough in terms of lightening the burden? Have they got the balance right here?
Well, I think the main objective was not to lighten the burden across the board on the aspects of MAR that affect issuers, but to do some tweaks on those areas where the risk of malpractice or wrongdoing was smaller, and where we could have a low hanging fruit to cut off some costs and complexity. So that affects buyback programs mainly. Although here issuers and intermediaries are affected alike, and the regime is being a bit simplified in terms of notification, etc. It involves, as you said, insider lists, Nick. And here there are not so many changes. ESMA is clarifying the regime a bit on who needs to hold the insider list, the legal persons, the natural persons that should be included in each list, and is going with the approach of a nodes of the issuer and those working for the issuer, and then so forth. So as a network of insider lists. It's true that there are some proposals on softening the keeping of personal data in a separated manner, as long as they can be incorporated when the regulator requires a list. But there is not a Copernican change in the insider list, and I can, I mean, you need to understand that probably on these, we supervisors are a bit biased because we are on the receiving end of those insider lists. We use them, we appreciate them a lot. They really make our work much easier and effective, and therefore it is to a certain extent understandable that the stance of the ESMA proposal on insider lists, and probably on market soundings, going back to the topic before, is probably on the hard end, let's say, but because the supervisors really appreciate that information a lot for the investigation. And the last thing, just to conclude, is delayed disclosure of inside information, where there are not that many changes, but ESMA recognizes that more guidance is needed to define the concept of as soon as possible, and the concept of immediate disclosure of inside information, which I think requires some reflection, not through level 1, but through guidance from ESMA.
Yeah. It's obviously an interesting situation we find in the UK. Certainly a lot of companies coming to the public markets having to raise money this year, quite a lot of secondary fundraisings, debt and equity and things like this. And so the burdensome nature of these transactions, we wouldn't want it putting people off coming to the public markets. I think that's probably where I'm coming from. I think, having to compete with more lightly regulated private markets, and certainly the equity market needs to be able to hold itself up against the debt markets and things like this. So it's an interesting balance to try and balance the regulation to make sure that the public, particularly the equity markets, do not become too unattractive for people and too burdensome. It's a debate I'm sure that we will continue with. So before I wrap up on the detail of this, anybody got anything else they want to pick up as a result of what we talked about, or come back in relation to any of those before we move on? Okay.
I guess the wrap up comment, I think the report is quite balanced in a number of places on FX, which we've spoken about before, and delaying a decision on that until the FX code update discussions have taken place. And I think there are a number of there's a lot of useful research in there on that side. And actually on insider lists, I thought there was a lot of commentary and varying practices demonstrated from different member states around permanent insider lists and event-driven insider lists. So I think it understood some of the challenges in a number of areas.
Yeah, good. Well, that's good to hear, isn't it? It's good to hear. Okay, thank you. We've talked about extraterritoriality and talked about the international aspects of this. We are less than 3 months away from the end of the transition period. Parking FX for the moment, 43% of global FX market is in the UK. Global FX market in the UK. If anybody should be regulating the global FX market or shouldn't be regulating it, it'll probably be the UK that decides, and maybe ESMA will follow, but we'll see on that. But looking at what's going to happen and looking at MAR and looking at the nature of these regimes and the detail that's in them, we could be moving to a situation where we've got two parallel regimes at some point. Initially, the indications seem to be that the UK will toe the line. We haven't got much. We've got Rishi Sunak's statement, doesn't really tell us a great deal. To be honest, we don't know much officially about what's going on with the FSA's thinking or the government's thinking about this. Would anybody really want to have two parallel but different regimes within the EU 27 and the UK in relation to market abuse? Maybe Anne, we'll start with you. What do you think in terms of potential for divergence in this area and what might happen?
Yeah, so I think the onshoring exercise that the UK is going through is absolutely key here, because as you say, what we will have in the UK is the UK specific onshored version of MAR, which will of course continue to apply in parallel to EU MAR. And the interesting thing that has been done in terms of onshoring MAR in the UK is that they've actually retained the EU 28 scope. So UK MAR will continue to apply to instruments traded and tradable in the UK, but also in the EU. So you can immediately see the potential for overlap. And as you say, how that plays out sort of depends on, which bit of MAR you are looking at. We've talked about market soundings a lot, and to the extent that you are caught by both regimes, but the market soundings requirements under both of them are the same, then perhaps that is something that's manageable. But as you say, therefore, divergence is really the key point to be monitored, because the further they start to split apart, the more difficult it becomes for people to comply with in practice. And perhaps we might therefore see that playing out, perhaps where you do have to make notifications, so buyback stabilizations, or again on the issuer side, PDMR notifications and things like that. There is the potential where you, at the moment, are making one notification, you may have to make two. So divergence, as you say, will be absolutely key, but I think there are still some touch points that will overlap in any case.
Thanks, Emily. Emily, any thoughts from you on that?
Yeah, I think this is an area that won't be the highest priority for the UK. I think financial market infrastructure and equivalence questions are bigger items. There are areas maybe where some London market practice has evolved, or UK approaches, including in the area of market sounding. So potentially we could see some divergence in time, depending on regulatory appetite and pragmatism in those spaces, which could be helpful for market issuance in London. But yeah, it's hard to know at this stage. Obviously, market abuse is an FCA UK priority, and I think the UK has input greatly into some of the requirements. So I don't think the regime is going to be fundamentally ripped up and revisited in the UK, if I'm a speculating person.
That must be right. I think that the UK had such an influence over MAR in terms of the shape of the regime and how it worked, and therefore it wasn't a colossal change really when MAR came in. So we will see, won't we? It's a really interesting topic. Rodrigo, did you want to come in on the issue of divergence and whether you think it has the potential to cause problems for the industry at some point?
Well, I think this issue of market integrity is a bit special, as I think Anne was mentioning. So it doesn't carry the E-word problem, the equivalence problem, because clearly it's not one that it has attracted the priority in terms of competition. But it is really serious. I mean, everybody's interested in having a clean market, and actually, market integrity, I think, is a public good. Nobody's worse off when you have more clean or more integrity, except crooks and people that violate the rules. So we need to take this in the long perspective, in the long run perspective. I think that it would be probably not very wise to diverge significantly, because of the type of questions that some of the co-panelists have pointed out. Imagine two market sounding regimes with two different record keeping or obligations, or imagine two buyback programs again, or two insider lists for consultants or for investment banks, having to keep them in separate manners. I think it doesn't make sense. So I think there is a strong reason or argument, if we want, to keep a big degree of convergence between the two regimes for a long period. Yes.
Yeah, good. We're glad to hear you say that, because it sounds like you'll be a man who'll have some influence over that. So that sounds good to us. I'm going to go to some of the questions on Slido and read these out, and please let me know if you're happy to take them. ESMA MAR review. What are the panel's opinion on whether ESMA comments will generate change to market practice prior to the legal implementation? I touched on this a little bit earlier when we were talking about pre-hedging. I don't know if anybody wants to come in and have a go at that one, whether actually people will anticipate these changes and market practice might evolve slightly. Anybody want to have a go at that?
I mean, I've certainly seen it being discussed already. Like we talked about it, as you say, in the pre-hedging context. You could also look at it in the market soundings context. Again, we talked about that sort of small portion of extraterritorial application. And I mean, the commentary I'm seeing is that, obviously ESMA is putting an opinion forward, but it does still need to be formalized. So I think, it'll be certainly a consideration, but whether we see market practice move now, I think that there might be a bit of a longer time frame for that.
Yeah, a lot of the people in your organisation, Emily, probably won't be reading 250 pages of MAR review and saying, let's change market practice, unless you tell them to, perhaps.
Yeah, and I think there are kind of pros and cons, aren't there? I think in many instances, ESMA suggests changes to the text. So without them having been implemented, it doesn't necessarily lead to market change, but there are open questions, I think, especially on market sounding.
Okay, good stuff. I'll take another question now. To what extent do you think other communication channels such as WhatsApp, WeChat, Zoom, etc. will feature in future guidance and market practice? Good question. Technology is something that has changed a lot of our lives over the last 6 months. Anybody want to come in on this? I mean, Rodrigo, maybe, have you got any thoughts on this?
Well, we are already looking as CNAV to elements like the use of social networks to disseminate this information from issuers. It's increasingly, regular that some issuers would use social networks, Twitter, and these kind of things to
it's allowed in
disseminate
the
information.
States, isn't it? It's allowed in the US, isn't it? It's actually,
yeah,
when Elon Musk tweets, it counts like a regulatory announcement, doesn't it?
And we may cover that relatively soon from the CNV side. And of course, when it comes to the use of other type of networks, not from the part of issuers, but intermediaries or professionals, that's something that we are also looking into. So I'm pretty sure that has already come to the attention of regulators. Yes.
It definitely feels like something which is changing all of our lives. I've got a question here. involuntary listing confusion. Issuers with securities traded on Deutsche Börse often don't know about it. Well, yeah, it's the German MTFs that are famous for this. What are the expectations and how may they change? I don't know if anyone's got a view on that, whether there's anything that regulators can do about this, having created this regime of the MiFID universe of instruments. Briefly, anyone want to think? Do we think they're going to change the universe of MAR, the scope of it, in order to avoid this problem?
I'm not sure the report really answers this or tackles this.
No.
So in all likelihood, it might not get picked up unless there's significant engagement with the European Commission when it's drafting the legislation.
Interesting. Yeah. Well, maybe it's something. Rodrigo, did you want to come in there?
I was just going to say that we need to look at this, as I said before, in a MAR MiFID perspective. I'm pretty sure that this element is on the table. It has caused a lot of problems on the trading obligation, and I'm pretty sure it will be dealt with.
Great. Well, it's really good to hear that, Rodrigo. Thank you. You got the message, you guys. Thank you very much. I think we're out of time. So what I'd like to say is, sorry if your question didn't get answered on Slido. Thank you. Thank you very much to my panel. Really interesting discussion, to Anne, to Emily, and to Rodrigo. Thank you very much for your time and your input. Thank you, all of you, for your attention. And I'll hand back to Louise for the rest of the conference. Thank you.
Apologies, I don't think you could hear me earlier. You should now be able to hear me. We've reached the end of the live panel discussions. Thank you to Nick for his excellent moderation of the very topical MAR panel. If you'd now like to choose your on-demand session, at the top of the screen, select the mainstream drop-down bar. We've got 2 new sessions today. We've got one on IBOR transition, which is moderated by Jeremy Walter at Clifford Chance. We've got another new session on recent developments in the world of data, and that's moderated by Vivian Arts, who is chair of the data workstream at the IRSG. And you can also view yesterday's sessions if you didn't have an opportunity to view them. They'll be available online for 2 weeks, so please enjoy the session that you choose, and I'll join you back here for closing remarks of the day. Thank you. Good afternoon, everyone, and welcome back. I hope that you enjoyed your on-demand session. Please remember that they're available for the next 2 weeks, and we'll be seeing you later. We look forward to you joining us tomorrow at 8:30 UK time. Before we do an overview of what's on the agenda tomorrow, just a quick recap of today. We started off with an excellent Brexit panel. I hope that you found that helpful. We then had a bit of a conduct and culture theme today, looking at new trends in conduct and culture, which I thought gave us a real insight into the business level of what's happening at firms. We then went into a phenomenal panel session on leadership, conduct and culture. And then we had some very topical and practical discussions on the market abuse regulation and the impact of some of the proposals in the MAR review. So I just wanted to say thank you to you for joining us today. Thank you to our moderators, to our excellent panelists, to the support team, and to my AFME colleagues in the background who've really done a stellar job in bringing day 2 to a close. Tomorrow, we've got a real action-packed agenda. We'll be joined by Verena Ross, who is Executive Director at ESMA. We'll then have a fireside chat with Tilman Luder, who is Head of the Securities Department at the European Commission. And then we lead into 2 really excellent practitioner-led MiFID sessions, and we'll close with some insight on approaches to surveillance and governance. So please do take time to have a look at the AFME booth. We've got a new video that we've uploaded today. We've got a variety of materials on all of the topics that we've covered in days 1 and 2 of the conference. And we've also got some material that will be relevant to day 3. Please have a look at the sponsor booths as well. There's lots of great material, reports, videos, insights. So do go and have a look at what's available to you. I'll say thank you for now. Enjoy the rest of your afternoon, and we'll see you tomorrow morning, 8:30 in the UK, 9:30 if you're in Europe. Thanks, everyone.